Good. Mr. Sopkin, I can't see you. You're all black and gray.
Yeah, I can't see me either. I don't know what's going on with my camera. Um, Hopefully we'll get this figured out quickly.
But you can hear.
I can hear you fine.
All right, we can hear you. All right. Good morning. Let's go on the record. It's 9 a.m. on July 24th, 2025. This is an evidentiary hearing in proceeding number 25A-0062E, Black Hills application requesting approval of its 2025 distribution system plan. I'm Eric Blank, the chair of the PUC, and I'm the hearing commissioner for this proceeding. Let's start with entries of appearance. Black Hills.
Yes, thank you, Your Honor. Greg Sopkin, Associate General Counsel for Black Hills Colorado Electric, LLC.
Trial staff.
Good morning, Senior Assistant Attorney General Katie McLaughlin and my co-counsels Aileen Chong and Ross Smith on behalf of trial staff.
Thank you. UCA.
Good morning, Your Honor. Kate Crampton with the Attorney General's Office on behalf of the Utility Consumer Advocate.
Welcome. Commission Counsel.
Good morning, Wendy Rosati, Assistant Attorney General for Commission Counsel.
Thank you. Did I miss anyone? Just a quick thing on electronic process. We're going to conduct this hearing using electronic exhibits. A spreadsheet marked as Hearing Exhibit 500 lists the latest versions of the pre-filed testimony and attachments. With that, any objection to the omission of Hearing Exhibit 500, the spreadsheet listing all the exhibits?
No objection.
None from UCA.
Hearing none, Exhibit 500 is admitted. Any objections or concerns omitting all the items listed on Hearing Exhibit 500? Mr. Sopkin.
No objection.
Anyone
No
else?
objection.
None from
Hearing
UCA.
none. Thanks. Hearing none, Exhibit 500 is and all the exhibits on it are admitted. As I understand it, witnesses Moeller, Turner, and Bongiordana Dina do not have any questions for them. Is that consistent with the party's understanding? I'm told Commission Counsel does not have any questions.
Consistent with my understanding.
All right. With that, I think we can excuse Mr. Moeller, Mr. Turner, and Mr. Dr. Giardina. Let's see. I think we're ready to get started. I have a couple of things, but just seeing if there's any preliminary matters. Ms. McLaughlin.
Thank you, Chair Blank. Just wanted to flag that our witness, Mr. Eric Hagland, has a conflict from 1:30 to 4. We're hopeful that the hearing will wrap up before that, but wanted to let you know in case you needed to call him out of order.
Okay, I think we're all hopeful the hearing will end before 1:30, but appreciate that, and we'll see how we're going. Maybe we'll take him before Mr. Villarreal if we need to. So thanks for the heads up. Any other preliminary matters? So before we jump into the first witness, I just want to say, Mr. Harrington, I think I'm going to ask that we jump in the confidential session, or Mr. Sopkin, I'd like to jump in the confidential session for some of my questions for Mr. Harrington. So maybe after UCA cross, we can take a 5 or 10 minute break, and you can help us make sure the right people are on the Zoom. Is that possible?
Sure, we could do that.
Okay, and then
Yes, sir.
Second, Mr. Harrington, I'm gonna try and I have a series of questions on your spreadsheet in the supplemental direct. Let me just get the right number. It's hearing exhibit 104, attachment MGH dash one. So after the break, if you could have a separate screen so we can go through that spreadsheet together, I'll try and share my screen. But if you could set that up so everybody can see you and you can look at the spreadsheet, that'd be great. So with that, I guess Mr. Sopkin, is that okay?
Oh, yes, that's fine.
All right. With that, Mr. Harrington, can you come on screen? There you are.
Morning.
Morning. Can you hold up your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
You can put your hand down. Is anybody with you or communicating with you in any way?
No, Your Honor, I'm in my office by myself.
If that changes, will you let us know?
Yes, I will.
With that, back to you, Mr. Sopkin.
Good morning, Mr. Harrington. I can see you, but you can't see me. Sorry about that. Please state by whom you're employed and in what capacity.
Yes, I'm employed by Black Hills Energy Service Company, and I'm the Director of Regulatory, and I'm here testifying on behalf of Black Hills Colorado Electric, LLC today.
And did you cause to be filed in this proceeding two sets of testimony and attachments, hearing exhibit 104, which is your supplemental direct testimony, and hearing exhibit 107, which is your settlement testimony in this proceeding?
Yes, that's correct.
Okay. Your Honor, at this point, I tender Mr. Harrington for cross-examination.
Thank you, Mr. Sopkin. Ms. Crampton, you're up, and I have 35 minutes.
Thank you. Good morning, Mr. Harrington. How are you this morning?
Doing well, thanks. Good morning.
Good morning. Mr. Harrington, I am going to focus a lot of my questions on your settlement testimony, and in particular surrounding the contested issue of the hosting capacity analysis and mapping, if that's just helpful for orientation. And if we could pull up Mr. Harrington's settlement testimony, which is hearing exhibit 107 at the bottom of page 9 and top of page 10, please. And Mr. Harrington, I just want to just kind of confirm that what you describe in your testimony is the agreement in this proceeding of the company and trial staff that the company will, quote, provide a detailed, updated cost estimate in its next DSP filing for the development of a hosting capacity analysis and map, and at which time the company would have the option of requesting a waiver to the rule requirement. Did I read your testimony correctly there?
Yes, you did.
Okay. And currently, the company has a cost estimate from the 2024 ICF consultant report. Is that correct?
That's correct.
And that 2024 ICF report details the 3 options for the company to develop and implement the hosting capacity analysis and associated map, correct?
You know, I don't recall the 3 exact options, but I do recall the dollar figure estimate, cost estimate, if you will, to develop the analysis for the hosting capacity map. And that was detailed in that IC that report.
Okay, and I was going to talk about this with your colleague, Mr. Ahrens, but if we could pull up hearing exhibit 302 from ucasbox.com, please. And Mr. Harrington, do you recognize this as the report provided by the consulting agency ICF to Black Hills for its 2024 report?
Yes, this looks familiar.
Okay. And if we could scroll to page 9, please. I'm sorry, if we could maybe scroll a little bit down page 9. I apologize, this looks a little different than my copy, so if I could have just a moment. If we could scroll, I think it's maybe, if we could keep scrolling, please. Okay, perfect, thank you. And Mr. Harrington, this table 3, we were talking a minute ago about the company's desire to provide an updated cost analysis in its next DSP. And currently, this is the cost estimate from its 2024 analysis, correct?
That's correct.
Okay. And specifically that figure in table 3 in row 3, column 2 costs, that's the $290,000 that the company has quoted in this proceeding as the current estimated cost to develop a hosting capacity analysis and mapping. Is that correct?
Yes, that's correct.
Okay. And as you stated, this is from the July 2024 report and the analysis provided by the consultants at ICF, correct?
Yes, correct.
Okay. And so what the company did with this 2024 report in this proceeding is that in this proceeding, the company has provided that cost estimate, and in doing so has also requested a waiver of these provisions of the rules regarding hosting capacity analysis and map, correct?
That's correct. Yes, we are requesting a waiver of the hosting capacity map analysis in this proceeding. That's correct.
Okay. And so that's where we are now in this proceeding, is we have the cost estimate and a request for a waiver, correct?
Yes, correct.
And what the company proposes, what the company and staff propose in the settlement term in this proceeding is that in the next DSP proceeding, the company will again provide an updated cost estimate with the possibility to request a waiver, correct?
Yes, correct.
And so if that settlement term is accepted by the commission, it's possible that in the next DSP proceeding, in 2 years, we will be exactly in the same position we are today with a cost estimate and request for a waiver, correct?
Yeah, I'm not sure I can speculate exactly. It's hard to know what we would do in a couple of years. I think the settlement agreement leaves the option open for another potential request. It could come back that there are some additional tools available. Maybe the cost estimates are reduced. And so it's hard to speculate right now what if we would request a waiver or not. The settlement agreement just preserves the company's ability to request a waiver if we deem it's necessary at that time.
Okay, and if we could go back to hearing exhibit 107 at the bottom of page 9 again, please. And so what the settlement term that you testified about, and that's contained in the settlement between the company and staff, is a commitment to provide an updated cost estimate and have the option of requesting a waiver, correct?
Yes, that's correct.
You mentioned that it's possible that the costs could go down. Did I understand that correctly?
I think it's possible, yes. Possible the cost could go up as well. The report was done about almost 2 years ago. So certainly possible, the cost would change.
Okay, and if we could just scroll down or up, I guess, through page 10. And right there, thank you. And actually, you sort of discussed this phenomenon of what you anticipate to happen with costs in the future in your settlement testimony, correct?
Yes.
Okay. And here in your testimony, you cite that current cost of one of the options in the ICF report, which is just under $300,000. Is that right?
Yes, that's correct.
Okay. But you state in your testimony that you think the actual cost to complete this analysis in a future DSP will actually be higher for 2 reasons. Is that right?
Well, I talk about here the testimony that there's 2 components. There is an analysis to generate the hosting capacity map. So that's one activity. And then there's a second activity is the cost of designing some sort of web portal or some sort of tool that would allow solar developers to have access to the hosting capacity. That's a separate activity. And so those 2 activities combined certainly could be higher than the 300,000. The $300,000 that we quoted there was really the cost for the analysis of the hosting capacity map, but it did not include cost for some sort of web portal or access to those maps.
Thank you. And I'm going to break that down. Let's set aside the web portal discussion for just a second. The cost that's just under $300,000, that's the cost from that ICF report, correct?
Correct.
And if
Thank
you. And I apologize, if we could pull back up here in exhibit 302 and scroll back to, I think what's the bottom of page 9 for me, but that chart, table 3, please. Thank you. And at this time, I'd move to admit hearing exhibit 3, or I'd ask the commission to take administrative notice under 1501 subsection C of hearing exhibit 302.
Can you scroll to the top again? Any objection?
No objection, Your Honor.
Thank you.
So noticed.
And we can take down hearing exhibit 302. And if we could go back to Mr. Harrington's testimony, hearing exhibit 107 at page 10, please. And so that first cost, the cost to sort of develop the hosting capacity analysis and mapping, that's the almost $300,000. And that's separate from the cost to develop the web portal as the company sees it, correct?
Yes, that's correct.
And with respect to that $300,000, as you testify, you anticipate that that cost will go up in 2026 or 2027 due to inflation, correct?
Well, I think it's likely to go up for the analysis of the hosting capacity map. I think that's likely to increase. The cost for the web portal, we're not sure what that cost could be. That could be some additional cost. It could be significant cost. That part we're not sure about yet. We haven't really evaluated the options for that type of web portal. But yes, the cost for the analysis, the consultant fees, I would anticipate those to increase.
Okay. And if the company's anticipation of these increased costs is correct, it would be less expensive for the company to develop and implement the hosting capacity analysis and mapping now than it will be 2 years from now in the company's next DSP, correct?
Not sure I can, I guess, give a affirmative on that. I think, the question that we have, more before us is it reasonable? Is it prudent to spend the money now? And frankly, we don't think it's a really prudent decision to invest the $300,000 now. We've been very successful at interconnecting solar customers, as I talk about here in my settlement
Sure.
testimony.
And Mr. Harrington, let me just jump in because my question was fairly simple. If the costs go up, as you anticipate they will, and as you provided in your testimony that you anticipate they will, to create the hosting capacity analysis and map in 2026, 2027, it would be less expensive now to conduct that activity, correct?
Well, the investment could be higher in a few years if we wait. However, as I stated in my testimony, we don't think it's a prudent decision to invest that money now. Our customers would be paying for an asset that we don't think is very beneficial or useful. And so from a customer viewpoint, I don't think it's a very prudent investment now to make.
If the settlement agreement term between the company and staff is accepted, and the updated costs that are calculated in the next DSP are in fact more expensive than the current 2024 costs, as you predict they will be, will the company again in its next DSP seek a waiver of the requirement to develop a hosting capacity analysis and map?
I'm not sure. I can't, speculate as what we will do or won't do in the next DSP. The settlement agreement simply preserves the option of filing a waiver. We will evaluate the circumstances, the cost, whether or not we feel like there's a demand and a need for it in the next case. I can't say here definitively that we will or will not file a waiver. The settlement agreement just preserves the right that we could file a waiver if we felt like we need one. I'd also add that if we do file a waiver, we would have to justify that to the commission and explain to the commission why a waiver would be warranted.
Thank you. And I'm going to follow up with you on that. But here in this proceeding, the company is seeking a waiver, and it's seeking the waiver based on the factor of the cost to customers to comply with this provision of the rules, correct?
Well, there's multiple factors. I think cost is certainly one of them. I mean, we've heard loud and clear from our customers and the commission about cost concerns and investment concerns. The second issue I note is that, frankly, we haven't had any demand for it from the solar industry. Our solar developers, our solar installers down in our service territory have been interconnecting solar systems very regularly without a hosting capacity map. And so we've been very successful at developing and building and increasing our behind the meter net metered customers without a hosting capacity map. And so from our viewpoint, the cost, the demands, the cost is a concern, and a lack of interest from the solar installer community. We don't feel like this is a prudent investment to make right now.
Okay, thank you for that explanation. If we could pull up from UCA's hearing exhibit, box.com, hearing exhibit 305. And Mr. Harrington, I'm showing you what's been marked as hearing exhibit 305. And this is a motion that Black Hills filed in this proceeding regarding its requested waivers. Do you recognize this document?
Yes, I do.
Okay, and if we could scroll to page 4, please. And Mr. Harrington, here is where the company discusses its request for a waiver of the Rule 3531A to A through F, correct?
Yes, correct.
And those are the provisions regarding hosting capacity analysis and mapping, correct?
Yes, correct.
And what the company states in its motion for the waiver is that the company believes the costs are excessive and would be a burden to customers, correct?
Yes.
And
correct.
therefore requests a waiver.
Yes.
I would ask the commission to take administrative notice of hearing exhibit 305, which is a motion filed already into this proceeding.
I'm not sure you need to do that. It's already in this proceeding, isn't it?
It is. I think the rules suggest I do need to do this, but I agree it's already in this proceeding.
I don't think we need to do it. So it's in evidence.
Okay, thank you. Mr. Harrington, the other cost of complying with this rule that you mentioned is the cost of putting the mapping, making the mapping available on the web portal, also pursuant to commission rules, correct?
Well, the one part of your question there, I'm not sure about is the exact reference to the commission rules, but I don't recall that part of the rule. But the other part of the cost is certainly to make it available to the to the solar developers.
Sure. And if it's helpful, if we could take down hearing exhibit 305 and if we could go back to your settlement testimony, hearing exhibit 107 at page 10. And so here, Mr. Harrington, you discussed that estimate, that $290,000 estimate, only discussed the costs related to the hosting capacity and mapping, but does not include the cost of a web portal, correct?
Yes, that's right.
Okay. And you cite in this portion of your testimony, you place a footnote, and if we could scroll down to that footnote too, please. Mr. Harrington, here you note that in that July 2024 report, the company developed a web portal range of costs between $553,000 and $810,000. Is that right?
Yes, that's correct.
Okay. This is a footnote in your testimony, correct?
Correct. Yes.
Okay, but you note that it's unclear from that range of costs what amounts would be specific to providing the hosting capacity map information, correct?
Correct.
And that there's other information that the web portal must contain pursuant to Rule 3541, correct?
Yes, that's what it says there. Yep.
Which is a different rule than the 3531 that discusses hosting capacity analysis.
Let me see. I don't recall the exact rule, but
Would you accept?
35, yes. Yes, I agree.
Okay. So from the information in your testimony, it's unclear what additional costs are required specifically for the web portal to fulfill the hosting capacity analysis rule requirements.
Yes, I would agree with that.
Okay. And so from the information provided in your testimony, the company does not have a final estimate of the cost of these measures in order for it to comply with the hosting capacity provisions of the commission rules, correct?
We have an indication of, of the 300,000 is a good indication of what it could cost now. The full service or full suite of a web portal, how you access that, how the developers, log in, the design of all that. We don't have a full range of cost estimates. As I
Okay.
said,
Thank you. You stated just a few moments ago, that it's the company's, the company must establish good cause to receive a waiver of the commission rules, correct?
I'd have to lean on my legal team on exactly what the requirements are. But I think I would generally state that if we're requesting a waiver from the commission rules, we have to explain and justify good cause as to why. I'd have to kind of defer to my legal team as to what that burden would look like. But I would state that, anytime the company's asking for a waiver, we have to explain and justify for good cause why it's warranted.
Okay, and if we could just scroll to page 13 of your testimony. And just at lines 8 and 9. Here, Mr. Harrington, you talk about the settlement term in this proceeding and sort of the plan for the next DSP. And you stated that in the next DSP, the filing, if the company were to seek a waiver, it would have the burden to show good cause for the waiver, correct?
Yes, correct.
Okay. And I know that you may need to consult with your legal team or not a lawyer, but is it fair to say that in this proceeding, the company would also have the burden to show good cause for the waiver it's requesting?
Yes, I would agree.
Okay. And we looked at the company's motion for the waiver previously filed in this case that discussed excessive cost to customers, correct?
Yes, correct.
Okay. And so the request for the waiver in this proceeding involves those estimated costs from the ICF report and the unknown web portal costs, correct?
Yes, correct.
Okay. If we could stay here on page 13, and actually just at the top of the page, here at lines 4 and 5, or I guess starting in line 2, you talk about UCA's position in this case. Is that right?
Yes, correct.
Okay. And you say in your testimony that UCA is asking the commission to, quote, order the company to incur the costs necessary to develop the hosting analysis. Is that right?
Yeah, just to finish the sentence, I talked about, before the next DSP filing.
Okay, but that language that UCA is asking the commission to order the company to incur costs, you would agree that that's your language, Mr. Harrington?
Well, certainly as I read the UCA's request of, denying our waiver, that's a consequence of denying the waiver. It would be to order us to make the investment. And so, by the UCA's opposition to our waiver request, the outcome would be that we would invest the $300,000 before the next DSP filing to comply with the commission rules.
Okay, and so the language is yours describing what you see as a consequence of UCA's recommendation to deny the waiver, correct?
It's the effect of the UCA's request would be to order us or require us to invest and make the investment now rather than do some more analysis and wait until later.
Okay, and put differently, UCA's recommendation to deny the waiver is a recommendation for Black Hills to comply with the rule, correct?
I think that's a consequence as well, or an outcome of the denial of the request would be that the company complies with the rule.
And you note here specifically in your testimony that UCA is requesting this happen before the next DSP filing. Is that right?
Yes, by denying the waiver request, we would then, be required to make the investment, spend the money, and develop the hosting capacity map and analysis.
And you would agree that this DSP proceeding already represents the company's second DSP proceeding, correct?
Correct. This is our second filing.
And that under the rule, the company was already required to comply with this rule.
I'm gonna object that this has been asked and answered several times. At this point, we're beating a dead horse.
I sort of agree, Ms. Crampton. If you can keep moving, that'd be great.
Yes, if we could pull back up hearing exhibit 302, please, and back to that table 3, please. And so, Mr. Harrington, kind of on this notion of the consequence of UCA's recommendation that the company comply with the rule is that it would have to conduct the hosting capacity analysis before the company's next DSP, which is estimated to be filed in early 2027, correct?
Yes, that's my understanding. That's how I would interpret the UCA's request. By denying the waiver would require the company to make the investment now, start building the hosting capacity map, invest in the tool, and we would have that ready most likely before the next DSP filing. It does take some time, or would take some time, to develop it and do the analysis. So it's likely that it would be available though before the next DSP if we were required or ordered to do it.
Okay, and in their report, ICF provided some timeframes that they estimated for the 3 options that they detailed in the report to Black Hills, correct?
Correct.
And 2 of those options, option 2 and 3, estimate about a timeframe of 6 months to complete this work?
Correct.
And the third option, or option number 1, they estimated about 15 months, correct?
That's correct.
Thank you. If we could go back to Mr. Harrington's hearing exhibit 107 at the top of page 14, please. And just directing your attention to starting at line 2. Here again, Mr. Harrington, you discuss that UCA is seeking to force the company to spend money, correct?
Correct. Yes.
And you say that UCA is doing so without providing any evidence that it will in fact benefit customers or result in any cost savings, correct?
Correct.
Put differently, the company notes that UCA, as an intervener in this proceeding, did not conduct or provide a cost-benefit analysis. Is that right?
Well, I think here I'm really referencing kind of the specific circumstances of our service territory in Pueblo. And, you know, when we think and look at these types of investments, you know, we look at whether or not our customers benefit from them. And you know, I didn't see anything from the UCA that discusses why our service territory and our customers in Pueblo would benefit from this. And as I talk a little bit in my testimony here, I find it a little surprising that the UCA is here requesting that we invest $300,000 when we just had a rate case where raising rates was a significant issue. And the UCA actually opposed any rate increase. So when I say here about cost benefit analysis, I'm really looking at, you know, does it really benefit our customers down in Pueblo? And we don't see any evidence that.
Yeah, and you know that UCA as an intervener in your judgment didn't provide this evidence, correct?
Correct.
Did you have the opportunity to read the testimonies of UCA witness Chris Villarreal?
Yes, I did.
Okay. And Mr. Villarreal discusses in his testimony benefits associated with hosting capacity analyses, correct?
Well, again, I think I would characterize
Mr. Harrington, it's a yes or no question. So in his testimony, if it's helpful, we could pull up hearing exhibit 301 at page 5, please. And if we could just scroll up a little bit, or down, I guess, a little bit. And Mr. Harrington, you recognize this is Mr. Villarreal's settlement testimony in this proceeding, correct?
Yes. Yes, that's correct.
And here, Mr. Villarreal notes that he will not repeat his arguments from answer testimony, but discusses benefits and why information from hosting capacity analysis is important or can be useful, correct?
That's correct.
Okay. And if we could go back to hearing exhibit 302, please. And I think it's going to be the bottom of page 1. The next page 1. Thank you. And if we could just, Mr. Harrington, I'm directing your attention. It's the paragraph that's at the top of the page, the sentence that starts the general purpose. Do you see that sentence?
Not yet. Oh, I think I see it. Okay, I read it.
Okay, and here, this is the report from the independent consulting firm ICF, correct?
Correct.
And here, ICF, your consultants, discuss the purpose of hosting capacity analysis and what this information can be used for, correct?
Yeah, I mean, the general purpose of a hosting capacity analysis map is to provide information and analysis to developers. I think our biggest issue is we've been providing this information to the developers already through a tool that we developed the last time. And we've been very successful with the tool and the map that we've had and the interactions that we've had with our developers. So the way we view these hosting capacity analysis is really an unnecessary investment. Certainly big utilities that have more flexibility and maybe more opportunities could benefit better. But we've been very successful at the way we've connected our solar installers in Pueblo specifically. And a hosted capacity map certainly generally has the purpose of providing information, but we've been very good and done a very good job of installing without it. And so frankly, we don't see the value of spending and investing the money when we've already been very successful installing and interconnecting solar customers.
Okay, and I understand your testimony that you don't see the value, or Black Hills doesn't see the value, but you would agree that both UCA witness Mr. Villarreal and the ICF report discuss the value or purpose that hosting capacity analysis can have for a utility.
Yeah, certainly. And I skimmed through, read Mr. Villarreal's white papers and all the various reports he provided. I would just highlight those examples are all done on very large utilities that have multi-millions, if not billions of dollars of investments. And here as a small utility that we're concerned about cost, it's just not really of significant benefit for us.
Okay, and we can take down hearing exhibit 302, please. And Mr. Harrington, just a few more questions. We talked about your testimony where you noted that in your judgment, UCA had failed to provide any evidence that the hosting capacity analysis would benefit customers or result in any cost savings. You recall that exchange between you and I in that portion of your testimony?
Yes, correct.
Okay. Is it your testimony here today that interveners must show with evidence why a commission rule should be followed? Yes or no?
Well, I'm thinking, because I think, as we talked about earlier, the company has the burden to explain why the commission rule is, a waiver of the commission rule is warranted. I think the burden for the interveners or the parties, I think there's certainly a requirement that the parties explain why they disagree with the company. I'm struggling a little bit with some of the exact legal arguments and maybe their legal position as to what they have to make. I'm not exactly sure about the burden of proof on the parties. But I would say that generally that the parties, though, they have to explain and support their position before the commission.
Okay. Let me ask it again. Is it your testimony here today that interveners must show with evidence why a commission rule must be followed?
Objection asked and answered.
Yeah, Ms. Crampton, we're very close to time, and I think you just asked that question, and I think the witness gave his best answer, so objection sustained.
And Mr. Harrington, is it your testimony that if in the company's judgment, an intervener has failed to establish why a commission rule must be followed, then the company has met its burden of showing good cause to waive the requirement of the rule?
Objection calls for a legal conclusion. It's really the same issue as before.
Yeah, I agree. Sustained.
I don't have any further questions. Thank you.
All right. Thank you, Ms. Crampton. Let's take a 5-minute break. Mr. Sopkin, if you could work with the legal analyst and commission counsel to make sure we're in a confidential session, that'd be great. And we'll come back at 9:55 with hearing commissioner questions for Mr. Harrington. Thank you.
Thank you.
Mr. Sopkin, redirect of Mr. Harrington. Back in
Yeah,
the record, out of confidential session. Sorry.
Thank you, Mr. Chairman. Just one procedural question based on the confidential session, which is, it sounds like you're going to issue an order indicating what we should be filing, or is it, I'm sorry, or maybe it's just a bench order that came out of that discussion and we need to make that filing.
Yeah, I'd prefer to, if you're all right with it, I'd prefer it be a bench order. And if you're willing to do that, I'm willing to condense the time to write a final recommended decision so we can keep this thing on track. So the request is for a bench order. If you want something in writing, I can.
Bench order is fine. We just would like to have some sense of your expectation of when that should be filed.
The sooner the better, I guess. I don't
Okay.
know. I defer to you. I don't really have a sense.
Okay. Well, we'll get that in as soon as we can.
All right.
I'm sorry. Mr. Harrington, just have a couple questions for you, and these first couple of questions do relate to the confidential session, but they're not confidential questions. So with regard to capital spending, can you briefly explain what the company's annual process is for determining its 5-year capital plan?
Yeah, certainly. So we go through an annual process every year. It's usually begins sometime in May, concludes in July, August timeframe, where the company and our finance team, we go through and look at the 5-year capital budget, so the next 5 years. And again, that's an annual process. And so what we presented in that spreadsheet that we were just looking at was the capital budget from last year. And so we're currently working on updating that capital budget. And I could say a couple of things that some of the things that we've certainly learned and heard feedback from Mr. Chairman, the commission, our customers, certainly concerns about the rate case. And so I can tell you that we're certainly going through right now, looking at our capital budget again very carefully, and trying to find ways to reduce some of those capital spending. You're still maintaining the adequate service that we're required to have. So I guess I just wanted to highlight that we are definitely taking to heart what some of the messages and the concerns about capital spending, and we're currently going through and scrubbing that next 5-year capital budget.
That would be greatly appreciated and would help as we determine regulatory lag in capital structure. So, sorry for interrupting.
And just one more question. When we looked at that spreadsheet showing base rate potential increases every year, is that dependent upon the filing of a rate case?
That's correct. And I talked about that a little bit in my supplemental testimony. So I certainly don't want to give the impression that we're going to change base rates every single year. Though the spreadsheet, just the way we set that up, it does show, kind of a change of rates every year. That doesn't really happen in the real world. The only way we change base rates is through a rate case. And so certainly I wanted to make sure that that was kind of understood, that if folks are looking at this, it should not be interpreted that we're filing a rate case every single year to change rates.
All right, let's turn to your earlier cross-examination by Ms. Crampton. Just for clarification, I want to put up Exhibit 302, which was, I believe, a box exhibit from UCA. And I believe there's a chart shown on page 11 of that document. Okay, and here this exhibit shows the 3 options that you talked about with Ms. Crampton that were analyzed by ICF. My first question is with that option 1, DNV synergy with consultant assistance and training. That indicates a cost of $68,675 plus BHE internal resource costs. And it also shows a BHE resource commitment of high. Do we know how much that cost would be for BHE to devote internal resources for this option?
I'm going to
No.
object. I believe that question is beyond the scope of my cross-examination.
I think this chart was referred to several times. Ms. Crampton referred to testimony that showed a range of 68 to 290,000, and I think we would like to explain what the full implications of that option one.
Overruled.
Mr. Harrington?
No, we don't. Yeah, I remember the question. We do not, I don't have an estimate. We don't have an estimate for that. Our, internal team is, we would need to really evaluate what the internal team and their availability and time commitments could be on this. So that cost estimate is not the full scope of the cost, certainly. If we're using our internal team to design and develop that tool.
And if the company needed to staff up specific for this purpose with regard to hosting capacity analysis and mapping and incurred cost as a result of that, would the company want cost recovery for that?
Well, certainly. I mean, if this is deemed something that the company should do, it'd be a prudently incurred cost. We would look for the ability to recover that cost.
And Ms. Crampton also was referring to the timing of when the company would need to spend the dollars associated with, and I think she was specifically asking about option 3, the $290,000. If the company is ordered to go ahead with this HEA, this hosting capacity analysis and mapping, when, and then here we're getting into inflation, when would the company need to expend those dollars prior to the next DSP filing?
Well, we would need to start working on it pretty soon. I think there's some initial time estimates there, as how long it would take, but knowing how long it kind of takes consultants to get engaged and get the contracts set up for them, working through our procurement process, that takes a little while. So we would probably begin the effort later this year, or start the effort this year, so that it would be ready in time for the next DSP filing.
And if the process were begun later this year and carried through, next year until the filing of the next DSP, would that cost $290,000 listed here? Would you expect that cost to be higher than the July 2024 estimate?
Well, for the analysis itself, it's likely to be higher. I think a full the part that we're not sure about is the web portal and the host and the distribution of the map, and that part we're not sure on. So, but I would think that the 290,000 would likely be higher.
Okay, thank you. 1 second here. All right, and if we could pull up hearing exhibit 300, please, which is Mr. Villarreal's answer testimony in this case. And I'd like to look at page 23. And looking and scrolling down to line 18, please. Mr. Villarreal testifies, similar to my comments on hosting capacity analysis and maps, providing information about the distribution system via an online portal is increasingly vital to the development of DER across Colorado and for Black Hills customers. Black Hills states it will cost between $550,000 and $810,000. And then he goes on from there. Is this the second part of the cost beyond the $290,000 discussed by the company, that the company's worried about incurring?
Yeah, that's right. That's that hosting capacity portal, or the, the availability of that, the analysis presenting it, and, that's a big range right there. And so we're not exactly sure. We haven't done any more detailed work on trying to figure out, pin down what that cost estimate would be.
Okay, for the second part of the cost, which is
Right.
Mr. Villarreal's desire for an online portal. Is that correct?
Right. Yes, that's correct.
Yeah, object to that form of question and move to strike. It's not Mr. Villarreal's version, it's what the rule states. So I just asked Mr. Sopkin to rephrase.
Yeah, if you could rephrase, Mr. Sopkin.
Sure. And is this the second part of the cost, the online portal part of the cost associated with the Commission Rule 3541 that the company is worried about incurring?
Yes, that's correct.
And you had indicated as part of your testimony on cross-examination that the company has been successful with DER implementation or implementation. Is that limited to solar rooftop customers?
Well, no, it's not. My settlement testimony certainly talks about the number of residential net meter customers that have interconnected. Over the past 10 years, we've interconnected many community solar gardens over the time frame. Those are larger scale solar projects. We've interconnected, I believe it's about 9 projects so far, and pursuant to our RES plan, we have several more coming in the next 5 years.
And has the company incurred any problems with getting that DER implemented?
Well, I think there's certainly challenges that we've experienced with the solar garden developers, and connecting site locations are sometimes an issue we have to work through. But we've met our RES plan. We've interconnected the solar gardens consistent with what our RES plan, and we've been following through with achieving those RES goals.
Okay, and there was a discussion with Ms. Crampton about, I guess it was about cost benefit analysis and whether Mr. Villarreal discussed the benefits of the hosting capacity analysis and mapping. Do you recall that?
Yes, I do.
And is the company saying that with regard to Mr. Villarreal's general description of benefits of HCA, is the company disagreeing that that might be a useful tool in some contexts?
No, I mean, I see the benefits that a hosting capacity analysis can have. I think, I read through the reports that Mr. Villarreal filed, and when I look at it for large utilities that have, millions of customers, I can understand why there's some benefits to those larger, bigger utilities. I think our challenge here, though, is when we think about Black Hills as a smaller utility with roughly 100,000 customers in a community that is very sensitive to rates and sensitive to our investment. We characterize this hosting capacity as a nice to have, not a need to have. And so I think, that's kind of our concern, and that's our issue with, not really wanting to make this investment.
Okay. All right, and Mr. Villarreal in his settlement testimony added some new information to the record with regard to some materials, I guess is the way he put it, from the Department of Energy, the Interstate Renewable Energy Council, and the Michigan Public Service Commission. You recall that?
Yes, I do.
Okay, and you,
I'm going to object to this line of questioning. I recognize that I asked Mr. Harrington in cross-examination to identify some benefits of hosting capacity analysis at a specific portion of his testimony. But this line of questioning appears to be going on the scope, beyond the scope of my cross-examination. And I know Mr. Sopkin will have an opportunity to cross-examine Mr. Virel, so I would object.
Yeah, I agree. Mr. Sopkin, this seems well beyond Ms. Crampton's cross and inappropriate for redirect.
okay, and I guess where I was going, and then you could tell me to stop, is the difference between Mr. Villarreal's description of general benefits as associated with utilities in general and Black Hill's specific circumstance based on its size. And so I was simply, Mr. Harrington referred to that in his answer to Ms. Crampton's question. So I was simply going to ask about the size of some of these utilities that Mr. Villarreal had referred to in these additional materials that he offered. But if you don't want me to go there, I don't have to go there.
Yeah, I think that it'd be better if you took that up on cross with Mr. Villarreal. It seems like this is not the place.
You bet. Okay, Mr. Harrington, why does the company believe it's unnecessary at this time and customers won't benefit from the hosting capacity analysis and mapping?
Yes, yeah, I think again, like I kind of characterize this as a nice to have, not a need to have type of tool. We've been very successful at interconnecting solar customers over the last 10 years. Our last DSP, the inaugural DSP, we developed an alternative tool that has been accepted. We don't have any solar developers banging down our door demanding that we have this available to them. Our solar installers are interconnecting customers without it. And so, we don't see a real need again to spend the money and develop this type of tool when we're doing we've been very successful so far.
And does the company believe it has a less expensive route than hosting capacity analysis and mapping by which developers can access the information they need from Black Hills for development of solar projects?
Yes, we do. We have a process in place where the developers can sign a NDA with us, and they can have access to some of our maps. And again, this is one of the benefits that I would say of a smaller utility is we have roughly 7 solar installers that are pretty active in our community right now, and it's very easy for us to work with 7 installers. So maybe for the large utilities that have multiple of millions of customers and dozens of installers, maybe some sort of automated system is more efficient. But as a small utility like Black Hills, it's much more efficient for the solar developers to just call us. We'll share the maps, we'll work with them, and we've been very successful at it.
And in addition to sharing the map, can the company on an ad hoc basis provide to a developer information about the amount of capacity available in different geographic areas of the company's service territory to accommodate a project?
I'm going to object again as beyond the scope of my cross-examination.
No, I believe this is the heart of the matter. We are talking about why this is unnecessary, and the entire basis of Ms. Crampton's cross-examination is that it is necessary.
Overruled.
Yeah, certainly. I think, like I just mentioned, I mean, we have, currently roughly 7 active solar installers, so, that are interconnecting, contacting our customers. We have a very efficient process. As I talk about in my settlement testimony, our process has been recognized by commission staff as being efficient, and we work well with our solar community. And so again, our stance here is this is a nice to have, not a need to have type of tool. And when we've been given clear signals from the commission and our customers about maintaining cost, this is not the time to make this type of investment.
Your Honor, those are all the questions I have. Thank you.
Thank you, Mr. Harrington. You may be excused.
Yep.
Mr. Ahrens, there you are. Can you hold up your right hand, sir? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. Is anybody with you or communicating with you in any way?
No.
If that changes, will you let us know?
I will.
Thank you. Ms. Crampton, it's 10:53 and I have 35 minutes. And I think I would like to take Mr. Hagland next, if that works for you, Ms. Crampton. Let's just get him in. Well, after the company's case, let's go with Mr. Hagland.
That works. I think we're just skipping one brief step. I think Mr. Sopkin maybe needs to introduce and present his witness.
Oh, yeah, sorry. Mr. Sopkin.
That's fine. Mr. Ahrens, by whom are you employed and in what capacity?
Black Hills Corporation. I am manager of regulatory in Colorado.
And did you file 2 pieces of testimony in this case, hearing exhibit 101, which is direct testimony, and hearing exhibit 105, which is your rebuttal testimony, as well as attachments?
Yes.
Your Honor, at this stage, I will tender Mr. Ahrens for cross-examination.
Now you're timely up, Ms. Crampton. 35 minutes and it's now 10:54.
Thank you. Good morning, Mr. Ahrens. How are you this morning?
I'm doing well. How are you?
Good. Thank you. Mr. Ahrens, I want to just level set. And I know there's been, you probably heard my cross-examination, Mr. Harrington, regarding hosting capacity analysis earlier, correct?
Yes.
And then Commissioner Blank had some questions sort of about a different subject matter. I want to return to the hosting capacity analysis, which you recognize and agree is sort of the contested term of UCA under the settlement agreement, correct?
That is correct, yes.
Okay. And so I want to level set on the background of the rules that give rise to this rule requiring the hosting capacity analysis and the company's request for a waiver in this proceeding, okay?
Okay.
And the background of the rules is something that you discussed in your direct testimony. Is that right?
That is correct, yes.
Okay. And what you discussed in your testimony is that these distribution rules really began with the 2019 legislation and passage of Senate Bill 19-236, correct?
Yes.
And part of that legislation required the commission to initiate a rulemaking to create and implement the requirements of SB 19-236, correct?
That's correct, yes.
And that rulemaking proceeding was 20R-0516E, correct?
That sounds correct, but I would put it subject to check.
Okay, if we could just pull up hearing exhibit 101 Rev 1 at the top of page 7. or bottom of page 6, top of page 7. And Mr. Ahrens, I'll just direct your attention. I'm going to have some questions about this proceeding, so I just wanted to make sure we're talking about the same rulemaking proceeding.
20R-0516E, correct.
Okay. And Black Hills, Colorado Electric actively participated in that rulemaking proceeding and had several opportunities to provide its comments and oral testimony, correct?
Correct.
Okay. And those comments and oral testimony included a discussion of the hosting capacity analysis and mapping issue, correct?
I believe that to be true, yes.
Okay. And if we could pull up from UCA's box.com hearing exhibit 308. And Mr. Ahrens, I'm just showing you the sort of caption. This is the initial comments of Black Hills from that rulemaking proceeding, correct?
That's what it appears to be, yes.
Your Honor, I would ask the court to take administrative notice of hearing exhibit 308.
Mr. Sopkin, any concerns?
No, no objection to the admissibility.
Thank you.
So moved.
And if we could scroll just to page 11 of that document, please. And Mr. Ahrens, here is the discussion of hosting capacity, proposed rule requirements, and Black Hills' position that there should be flexible rule language to permit utility exceptions. Do you see that?
Yes.
Okay. And as part of the participation in this rulemaking, Black Hills also had the opportunity to provide its own red lines to the proposed draft rules provided by the commission, correct?
I believe that to be true, yes.
Okay. And if we could, we can take down hearing exhibit 308. If we could please pull up hearing exhibit 307 from UCA's box, please. And Mr. Ahrens, I'm showing you what's been marked as hearing exhibit 307. And do these appear to be the red lines, or I guess blue lines of Black Hills in this rulemaking proceeding 20R-0516E?
Yes.
And if we could scroll down to page 11 of this document as well. I'm sorry, at 7, I'm sorry, page 7. If we could just scroll right down to the bottom. And here, Mr. Ahrens, this is where Black Hills submitted a red line applying to utilities with fewer than 500,000 customers, that they be exempt from the hosting capacity analysis and mapping requirements in the section previous, and that they only be required to provide the Excel spreadsheet or equivalent format of the feeder information. Is that correct?
That's what appears to be the blue line in that section you're referencing, yes.
Okay. And so in its blue lines, Black Hills essentially proposed to eliminate the requirement of for utilities with less than 500 customers to create the hosting capacity analysis and mapping, correct?
Yes.
Ultimately, the commission received this input from Black Hills as well as the other participants and issued a final decision and rules, correct?
That is correct, yes.
Okay. And if we could pull up from UCA's box.com hearing exhibit 306. And if we could scroll to page 102, please. And if we could just scroll a little bit down. And Mr. Ahrens, these are the final rules that the commission promulgated subsequent to that rulemaking procedure, correct?
What it appears to me to be, yes.
And Your Honor, I would move the commission to take administrative notice of its rules and specifically this provision of 3531A2.
Mr. Sopkin?
Not sure it's necessary. It's the commission rule, but that's fine.
Thank you.
Sorry. So noticed.
Thank you. And Mr. Ahrens, if we could just scroll down, I think there's a subsection G that might be on the next page. And Mr. Ahrens, you're aware from your review of the rules that the commission rejected Black Hills's recommendation that the hosting capacity analysis requirement be eliminated altogether for utilities with under 500,000 customers, and instead created a one-time exemption for the utility's first DSP filing, correct?
Objection calls for legal conclusion.
If you could rephrase, Ms. Crampton.
Sure. Is it your understanding that the commission adopted Black Hill's recommendation to eliminate the hosting capacity analysis for utilities with 500,000 or fewer customers?
I'm not an attorney, but yeah, I agree with you that the rules do allow that for the first time, but I also note that the commission rules also allow for the company to request waivers from the rules, which is what we have done in this case.
Okay. And you've requested a waiver in this case because you would need a waiver for a second or subsequent DSP.
Yes.
Okay. And so the commission had considered the input of Black Hills, but did not adopt it as offered by Black Hills, correct?
Your Honor, I'll object. I think this is incomplete. If Ms. Crampton wants to come to a conclusion like that, I think we need to introduce the actual decision in which the commission recognized that smaller utilities such as Black Hills should develop their HCAs in a phased approach, as Black Hills does not have the software capability to provide hosting capacity maps. So I think this is misleading and incomplete.
Ms. Crampton, do you have a response?
I think that Mr. Sopkin is welcome to ask the commission to take administrative notice or introduce such documents and redirect if it's appropriate. I disagree with the characterization that this is misleading.
Overall, you can keep going.
That's what it appears to be in the rules. I don't recall that I've ever reviewed the commission order approving the rules, so I don't know what that content has.
Okay, thank you. And Mr. Ahrens, would you agree that when the commission has promulgated the rules, that this is the commission telling the utilities in this instance what they need to do?
Objection calls for legal conclusion.
If you could rephrase.
Did you hear Mr. Harrington's discussion just a few minutes ago about things that are nice to have versus need to have?
Yes.
Yes. Is it your understanding that the rules are suggestions of what's nice to have or things that the utility needs to provide?
Objection calls for legal conclusion.
I think this witness
Overruled.
can,
Overruled.
I do believe that the rules state what the commission expects to be in the filing, but the rules also allow for the company to ask for waivers of rules, which is what we've done.
and as you see the document in front of you, you would agree that Rule 3531 does not create a hosting capacity analysis exemption for utilities with fewer than 500,000 customers' second DSP filing, second or subsequent DSP filing, correct?
Yeah, the rules speak for themselves, yes.
Okay. I want to now talk about the company's first DSP filing, which you discuss in your testimony. That was proceeding 23A-0357. Does that sound familiar?
It does.
Okay. And in that first DSP, the company filed a request for waivers, including a waiver of Rule 3531 concerning hosting capacity analysis, correct?
I recall that, yes.
Okay. And if we could pull up from UCA's box, hearing exhibit 310. And Mr. Ahrens, do you recognize this document as the motion filed by Black Hills in its first DSP, making requests for waivers of certain rules?
Yes.
Okay. Your Honor, I would ask the commission to take administrative notice of hearing exhibit 310, which is a document from its own files in proceeding 23A-0357E.
Any objection?
Objection.
So noticed.
And if we could scroll to page 4 of this motion. If we could just scroll up a little bit. And here, Mr. Ahrens, this is where the company makes its request for waiver of the rules concerning the hosting capacity analysis and mapping, correct?
Yes.
Okay. And the company cites the costs that it believes this exercise will entail, correct?
Yeah.
And here the company states that it believes that these costs are excessive and would be a burden on its customers, and therefore requests the waiver, correct?
That is correct, yes.
Okay. And that's the same request it's made in its request for a waiver in this proceeding, correct?
Yes, that is.
And we can take down here in exhibit 310. Thank you. Subsequent to that request, the assigned administrative law judge issued an interim decision which granted a waiver of Rule 3531 concerning hosting capacity analysis, correct?
That's my recollection, yes.
Okay. And that waiver, the company understood, applied to that specific proceeding.
Yes.
The company did not understand that to be a permanent waiver of that rule.
Yes, that's correct.
And after that interim decision issued approving the waiver of 3531 for that first DSP, the remainder of the case achieved a settlement agreement, correct?
That's my recollection, yes.
And as part of that settlement agreement, the company received several additional waivers and also made commitments that the company would fulfill between that first DSP and this second DSP, correct?
Objection relevance.
Overruled.
Yes.
Okay. And part of those commitments was to file an interim report in July of 2024, correct?
Yes.
Okay. And you've heard some of the discussion about the July 2024 report earlier this morning, my conversation with Mr. Harrington, correct?
If I do recall that.
Okay. And you, in fact, were the author or the individual who filed that July 2024 report for Black Hills.
I believe I was, yes.
And if we could pull up from UCA's box, hearing exhibit 303. And Mr. Ahrens, I'm showing you here in exhibit 303. This is the July 2024 report that was filed into that prior DSP proceeding, correct?
What it appears to be, yes.
Okay. And in that July 2024 report, the company had provided an update of its evaluation of methods of performing HCN mapping, as well as the timeline and costs of making such information available, correct?
Yes.
Yes.
Yes, I'm sorry. I'm getting a message that my internet is not stable. So if I say something you don't hear me, please let me know. I'd be glad to repeat it.
Okay, I think you were just a little quiet, but we can hear you.
So far, so good.
Okay, great.
And for that July 2024 report, the company worked with third-party consultants from an organization called ICF to develop an understanding of its options to complete the HCA and associated mapping, correct?
That is correct, yes.
Do you know if ICF is a consulting company local to the company's service territory?
I don't know where they're located.
And your July 24 report cites to the ICF analysis and sort of their conclusions with respect to HCA analysis and associated mapping, correct?
Yeah, I believe there was an appendix to this report that was an ICF report that had that information on it, yes.
Okay. And if we could just scroll to, I think, page 9 of this document. And here, Mr. Ahrens, this is where you discuss the ICF report and the options, the sort of 3 options that the ICF report provided for developing HCA and associated mapping, correct?
Correct.
Okay. And you refer to that Appendix D as the ICF report on this issue, correct?
Yes.
Okay. We can take down this hearing exhibit 303, please. And if we could pull up hearing exhibit 302 at 290, or I'm sorry, at page 11, please. And Mr. Ahrens, you recognize this ICF report that you incorporated into your July 2024 report, correct?
Yes, I do.
And you've heard the discussion about the options, and in particular, the third option that ICF provided is that $290,000 option that was discussed in your testimony as well as Mr. Harrington's testimony as the estimated cost for Black Hills to do the HCA and map, correct?
That is correct. That's for the development, not the operation of it.
Okay. And they have 3 different options, and those options differ based on cost, time frame, and the amount of internal Black Hills resources that would be required to implement these options, correct?
To implement, yes, but not to operate.
Okay, to implement the HCA and MAP.
Correct, but does not include estimates of the operation of maintaining the HCA.
Okay. And the $290,000 option requires less involvement from Black Hills internal resources and takes less time, correct?
That's correct, but it's also a more intensive system for us to maintain.
Okay. And then there's option one, which is significantly cheaper, coming in at about $68,000, but would take longer and require more internal resource commitment from Black Hills.
That's correct, yes.
Now, the company in its testimony in this case has only cited to that $290,000 as the estimated cost, correct?
That's correct, yes.
And is that because if the company were to pursue this hosting capacity analysis, it has decided that it would pursue option 3?
I don't believe that the company has made a decision on whether or not what option it would advocate for. And if it was, I haven't been part of that, so I don't know.
Okay. But you would agree that the $290,000 one is the one that is cited to in your testimony?
It is, yes.
Okay. And is it cited to because Black Hills lacks the internal resources to participate in the development of hosting capacity analysis and mapping?
I can't answer that question. I think Mr. Bockorny might be a better one to ask that question of.
Okay. Is there any evidence in the record that you can point to demonstrate what Black Hills has done between now and, or I guess since 2019, to develop internal resources, including to develop internal resources so that it is able to fulfill its obligations under the hosting capacity analysis rules?
I believe that Mr. Harrington testified earlier today that we do have processes in place. We, as part of that July 1st report, we have mapping that shows geographically where our distribution system feeders are located, where the substations are. We've also provided attachments that show what the peak loads of those feeders are. And as Mr. Harrington said, we are available to work with developers to provide the map and to provide information on what the loadings of those facilities are to help them site facilities that don't require as much interconnection costs. So yes, we have kind of developed a system that probably doesn't match with what the rules are, but accomplishes the goal.
Okay, so I think if put differently, Black Hills has committed some internal resources towards achievement of hosting capacity analysis capabilities.
I think that's a fair statement, yes.
Okay. And in your testimony, you did not discuss what it would take to take the commitments Black Hills has already made and pursue option 1 provided by ICF, correct?
Could you repeat the question, please?
Sure. I think it was not a great question. We just talked about the work that Black Hills has done sort of in the realm of hosting capacity analysis. My question was, in your testimony, you did not discuss how Black Hills could take the work that it's already done and apply it to option 1 to fulfill the hosting capacity analysis and mapping requirement of the rule. That's just not something you discussed in your testimony.
Yeah, and I don't think that, I think that what we have done is helpful in providing information to developers to allow them to site facilities and avoid some interconnection costs. But I'm not too sure whether or not the processes that we have adopted match up with what the rules are. And I think these estimates are what it would take to do and accomplish what the rules require. So to me, there's a little disconnect because I don't think that necessarily what we have done necessarily aligns well with what the rules are. I still think it's a very effective and meaningful way of trying to get what the rules are trying to get at, which is making it more friendly for development without having to pay high interconnection costs. But I don't think it matches with what the rules require.
Okay. And just, I hear you. And so just to be clear, we've got kind of the bucket of information the company currently has, but we don't have any testimony or information about this record about how to take that and maybe pursue option one as described in the ICF report.
I'm not too sure whether or not there's anything that we could do that would change these estimates. I think these estimates are still accurate.
Okay. If we could hold on to this exhibit and scroll up to, I think what's page 3. And the bottom of page 3, please. Thank you. Mr. Ahrens, you discuss in your direct testimony that the current distribution system of Black Hills involves a lot of aging infrastructure. Is that right?
Yes, that is.
Okay. And we've talked, and you heard my discussion with Mr. Harrington about sort of purposes of hosting capacity analysis or benefits of hosting capacity analysis, both from UCA witnesses as well as from this ICF report provided to Black Hills, correct?
Correct.
Okay. And just looking at that paragraph under regulatory objectives, and the last sentence of that paragraph, here, what ICF has identified to Black Hills is that hosting capacity maps can be used to increase transparency and help identify where DER may be accommodated with limited requirements for system reinforcement, correct?
Yes, that's correct.
And in their report, in ICF's report, they did not state that hosting capacity analysis is limited to benefiting solar developers, correct?
I don't recall ICF addressing that, so I think that's probably a fair statement.
Okay. And is ICF the only organization that the company consulted with in development of its July 2024 report?
I think that's a correct statement.
In your testimony, shifting gears a little bit, in your testimony, you discussed this stakeholder involvement in your DSP processes. Do you recall that portion of your testimony?
I do.
And with respect to this DSP, this 2025 DSP, there was just one stakeholder meeting that occurred on October 22nd, 2024, correct?
There was one stakeholder meeting, but there was also communications with developers, one-on-one.
And those meetings are one-on-one with the developer, separate from a stakeholder meeting, correct?
Correct, yes.
And here, the one stakeholder meeting occurred just before what would be the 90-day deadline to occur before filing the DSP, correct?
I believe that's correct, yes.
And the stakeholder engagement meeting occurred almost 3 months after the filing of that July 1st, 2024 report.
That sounds about right, yes.
We've talked a little bit about it, and I talked about it with Mr. Harrington. But as in the company's first DSP, in this proceeding, the company filed a motion requesting a waiver from Rule 3531, correct?
That's correct.
And in this motion, the company cites as its basis for the request for the waiver the costs, anticipated costs of development of hosting capacity analysis and mapping from that ICF report, correct?
That is correct, yes.
Mr. Ahrens, would you agree that in this proceeding, and unlike the 2023 DSP proceeding, the commission has not issued any interim decision granting the request for the waiver of Rule 3531?
I don't recall seeing an order that granted any waivers prior to this hearing, so I agree with you.
And you kind of came into this hearing today believing that this was a live issue.
Yes.
And as you testify here today, you haven't received any update that there's been a grant of the waiver?
No.
And today, July 24th, is approximately 6 months from when the company filed its DSP and its request for a waiver of this rule, correct?
Yes.
And despite not receiving any interim grant of its requested waiver, the company has not moved forward with its development of the HCA, or the hosting capacity analysis and mapping, correct?
That's correct. There's a waiver pending. So until we get a final order, we don't have certainty on what the commission's direction will be.
Okay. And so I think Mr. Sopkin discussed with Mr. Harrington sort of the timeframes of what could happen if the commission orders the company to comply with that rule. But you would agree that today, as we're 6 months out from when the company made that waiver request, that 6 months is the timeframe estimated by ICF to pursue development of HCA under both option 2 and option 3.
My recollection, yes.
Okay. And we're over a year out from when ICF first provided that report and provided that 6-month timeframe.
Yes, that's correct.
Okay. And because the company has chosen not to develop and implement an HCA analysis and associated map, even in the absence of a commission ruling on its motion for a waiver, is there currently a way for the company to meet the HCA requirements of the rules for this DSP?
Your Honor, I'm just going to object. We've made a request for a waiver, and this cross-examination gets into why haven't you complied with this rule? We've made a request for a waiver is the answer, and this keeps being.
I agree.
I'm sorry.
I agree, Ms. Crampton, and we're at time. So,
Okay. I'm all done with my questions. Thank you.
Thank you. If you could take that down. I just have a couple questions for you. Can we pull up hearing exhibit 101, your direct testimony at page 25? It sounds like the company, and I think you talked about this a little with Ms. Crampton, it sounds like the company hosted 2 meetings in Pueblo, both in October of 2024. Is that right, Mr. Ahrens?
You know, I corrected that testimony. When I originally filed, I thought there was, in fact, 2 meetings. Turns out there was only 1. So I corrected that. The alternative to that second meeting was what I was discussing with Ms. Crampton, where there was some outreach with developers one-on-one.
Okay. And can we go to the bottom of that page line 2022, 2020? It says, can you just summarize what the feedback from the community was from that October meeting?
I was not present at that October meeting. My understanding is I think I've got the slide deck that's an attachment to the testimony. My recollection from discussions with people who were at the meeting is that there was no recommendations that came out of that outreach, other than there was concerns about high prices. I know, Chairman, that you've been at public hearings involving Black Hills, and that's a common theme. That was my understanding of what feedback of that outreach was too.
All right. So it's this as a desire to maintain rate stability. So you'd agree with that?
Yes.
Okay.
Yes.
And I think Mr. Harrington testified that average annual distribution capital spending is being proposed to increase by 78% from 2026 to 2029 as compared to historical levels. Would you have any reason to doubt that characterization of his testimony?
I was listening on to that, so I can say that, yeah, I heard him testify to that, yes.
All right. And we can take this down. I can pull up, I mean, we don't have to pull it up, but it's hearing exhibit 103, attachment TAB-1. And on page 108, there's a presentation to the community. Is it fair to say at that October presentation, and since then, you haven't informed the community or presented to the community the size of the distribution capital spending increase? I mean, I can pull it up and we can go through it, but are you aware of this being presented to the community?
I'm not aware of that being presented to the community.
All right. And just last question. It seems like the primary thing this community cared about was rate stability. And we'll see what Mr. Harrington says back, but it seems like this filing may result in a material rate increase through increased distribution spending, and will certainly establish a much higher baseline of distribution capital spending. Given their concern, shouldn't we somehow find a way to present this to the community?
Well, certainly I don't think that there's going to be an increase of rates as a result of this case. And as I heard Mr. Harrington testify, that we are in that 5-year budget process, and we are looking closely at ways that we can reduce some of those spends. So I think that we are looking at some of those things, but yeah, that is a common concern that we've heard, and we're aware of it.
All right. I mean, I get rates aren't changing as part of this, but is there any other opportunity for this commission to look at distribution capital spending before the next rate case?
It really depends on when the next rate case is. The cadence of these DSPs are every 2 years. So, there's a possibility. Yeah, and the next one will be filed about 18 months. So my guess is that you will probably see a DSP before you see a rate case. But I don't know what the cadence of rate cases are.
Fair enough. Mr. Sopkin, redirect.
Yeah, very brief, Your Honor. Mr. Ahrens, well, first I'd like to pull up it's box hearing exhibit 109. And Mr. Ahrens, I think you had a discussion with Ms. Crampton about the rule making that adopted rules relevant to distribution system planning. Do you recall that discussion?
I do.
And you were shown Black Hill's comments and Black Hill's proposed red lines, as well as the rules that the commission adopted in this proceeding number 25A-0062E. Is that correct?
That is correct, yes.
Okay, if we could, well, first off, I'd like to take administrative notice of this decision.
Any objection, Ms. Crampton?
No, thank you.
So noticed.
Thank you. If we could turn to page 22, paragraph 65. Mr. Aaron's, could you read paragraph 65
Would you like me to read it out loud or just to myself?
out loud?
The recommend decision recognized that smaller utilities such as Black Hills should develop their HCAs in a phased approach, as Black Hills currently does not have the software capability to provide hosting capacity maps. The decision emphasized that working towards deployment of robust HCA and in turn better coordination on the distribution system would yield long-term savings rather than net cost for all utilities.
Okay, thank you. And we could take this down. Mr. Aaron's, based on your testimony regarding the ability to work with developers in the company's service territory to help them identify locations and opportunities for projects, do you believe that the company is in fact working towards development of robust HCA and better coordination on the distribution system?
Yes, I do.
Those are all the questions I have.
Thank you, Mr. Ernst. You may be excused.
Thank you.
Your Honor, one strange item that just came up is we were just informed that the fire marshal is going to run a test on our alarm at noon. Sure, we all don't want to hear the fire alarm at noon, so just as a timing matter.
Yes, we will take our break, our lunch break before 12. Let's see if Mr. Bacorny, are you there? Sorry for slaughtering your name if I did.
No. All good, all good.
Can you hold up your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
You?
You put your hand down. Is anybody with you or communicating with you in any way?
No, I am in an empty office.
If that changes, will you let us know?
Will do.
Can I just jump into it? Mr. Sopkin, I think his testimony is in.
You bet.
Can you help me integrate understand how you integrate affordability and long-term rate impact concerns into your distribution planning process?
So I guess the way I'd maybe answer that, again, I purely look at kind of, again, overloads of the system. What are the needs of the system? I'm purely looking at, what do we need to essentially serve those customers? And looking out into that, DSP gives us that opportunity to ultimately, look at a robust planning study. And so we make those investments purely on kind of what comes from that as one example. I know there's many other ways that we do invest into our system. But I would say from the rate impact, that's something I would have to lean more on Mr. Aarons or Mr. Harrington to help address with that question.
I mean, it seems to me that at least for me, the fundamental issue is the trade-off between much greater distribution capital spending and enhanced reliability on the one hand, and higher customer rates on the other. It sounds like as you identify the distribution investment that's needed, you don't struggle with that trade-off.
Maybe an example I provide, I guess, on that one, again, I don't know if we necessarily would say, here's my trade-offs. But as an example, from our 2023 filing to this filing, we did identify where we had recommended two new substations be upgraded, or two substations existing that need to be upgraded. In this filing, we identified that, due to how we had put together our forecast, it was, we were able to adjust and remove those from that capital budget. So from that standpoint, in my mind, I assume that would have an impact to our customers from a rates perspective. So, from that perspective, that's how I would probably look through that lens.
All right, that's all I have. Any redirect, Mr. Sopkin?
No redirect, Your Honor.
Thank you, sir. Appreciate it. Should we take up Mr. Haglund and see if we can get him in before lunch, and then we'll finish with Mr. Villarreal. Mr. Haglund.
Yes, I'm here. Can you hear me, Chair Blank?
I can hear you. I can't see you.
Yeah, I'm not sure why that is. I have turned on, let me try turning off and on again.
Ah, there you are.
I don't know how the actual lens window got closed, but always a good thing to check that one. So
the world needs to see your tie and jacket. So can you hold out your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Put your hand down. Is anybody with you or communicating with you in any way?
No.
If that changes, will you let us know?
Yes.
And Mr. Smith, since Mr. Haglund's testimony is already in the record, can I just jump into it?
That works for me, Chair.
All right, thank you. Is it fair to say that additional capital spending by Black Hills grows rate base, at least net of depreciation?
Other things being equal, yes.
Okay. And utilities earning growth is directly driven by rate base growth. Is that right?
I would say that's a large component of it, sure.
Okay. And so an investor-owned utility like Black Hills can increase its earnings by spending more capital. Is that fair?
Yes.
Okay. And is it possible this incentive that utility grows earnings by investing more capital could influence and shape a utility's capital spending decisions? Is that possible?
Yes, absolutely. I think what we commonly refer to as CapEx bias or capital bias is something that we're always attentive to in these proceedings.
All right. And as background for the next conversation and questions, just assume this commission is not, or assume we're not pushing towards a multi-year rate plan or a future test year. So it's just put that aside. Can we pull up your answer testimony, hearing exhibit 401 at page 9, line 9? And can you just read that paragraph to yourself? And if you can scroll down to the bottom, that'd be great. Yeah.
Okay, I've read it.
All right, and you see that last sentence, staff sees no way to reconcile the traditional prudency standard with a pre-approved level of capital spending. You see that, right?
Yes.
All right, you can take this down. I want to talk with you about generation planning. Are you generally aware that Black Hills just completed a phase 2 ERP in Colorado?
I am generally aware, yes.
And let me represent to you in that case, Black Hills initially proposed owning and rate basing a 200 megawatt solar project, in part to address long-term rate impact concerns The commission, through an ERP Phase 2 notice and comment dialogue with Black Hills and other parties, ultimately declined to approve that project and supported a smaller and cheaper one, at least on a dollar per kW construction cost, 100 megawatt solar project. Subject to later check, would you accept that representation? And I'm not going to get into the details.
Yeah, I can accept that reputation. I'm not personally familiar with those details, but I'll accept your representation.
All right. So basically, on the generation side, in that Black Hills ERP case, the PUC set an approved level of capital spending that specified individual generation projects along with associated PIMs. Is that a fair characterization of what we do all the time on generation? Would you say that differently? But we're setting capital spending levels. We're predetermining it before the expense is investment occurs, and we have PIMs that require the utilities to share the cost of going over and reap the benefits of going under. So I don't know. Would you say that any differently?
Well, I guess one distinction I would draw between the sort of generation context and the distribution context, I think generation investment is made up of larger discrete projects that have, individual CPCN applications, and the commission in recent years especially has tended to attach PIMs based on the expected capital presented sort of on a project by project basis in those proceedings, and the outcome of a CPCN proceeding tends to confer a higher level of expectation that the resulting investment will be considered prudent. I think I have a little bit more difficulty applying that to distribution investments, which are less discrete, and I think what's being considered in this proceeding is more of sort of a blanket level of capital spending to cover a whole myriad of investments, and that would be harder to assess sort of the prudency in advance one by one of those projects.
Yeah, we'll get there in a second, but I mean, you say there's no way to reconcile the traditional prudency standard with a pre-approved level of capital spending. That just seems patently not the case with generation. We do it all the time. We set a predetermined level of capital spending, and then I'll keep going, and then we set a presumption of prudence for those resources that are approved, and a presumption of imprudence if the utility went away from the approved resource. So we do this all the time on the generation side. So I'm just asking you if
I guess
you agree with that characterization.
Well, again, I haven't really been involved in most of those proceedings, but I think that the distinction I'm trying to draw here is one of timing. And I think if I understand your question correctly and how those proceedings have tended to go, the commission is setting the PIM at the same time the company is estimating costs for a discrete project. And that's also when this kind of presumption of prudence attaches. So what I'm concerned about in this paragraph you're asking me about is, if the commission decided in 2025 to set a level of capital spending that would apply in 2028 or 2029 to projects that haven't been fully developed and ready for construction at that point, the way that they're not at the level of development that a CPCN application tends to be, that I think the commission has different information at the time it would set that level of capital investment than the company has when it has to go forward with the project.
I'm still not asking anything about distribution, but just keep going. Focus on the generation side for a second. Let's assume that there was no ERP process. In this alternative reality, again, on the generation side, Black Hills might have built the 200 megawatt solar project that we denied approval on. And then is it fair to say the only remedy to staff, other stakeholders in this commission would have been to try and deem some portion of that investment imprudent at the time of a future general rate case? without ERP. Is that a fair characterization about how after the fact prudency review would work?
Specific to the prudency determination, I think that's accurate. I would emphasize again that in the ERP context, which you're asking me to focus on, there is the advantage of kind of a all source solicitation, a competitive dynamic, a sort of whole modeling exercise that allows for parties to evaluate alternatives.
Yeah, but and fair enough. If we didn't do that process, then we'd be stuck after the fact, trying to figure out whether the investment was prudent, and it's already sunk, so there's nothing you can do. Would you agree that that's the result if we didn't have the ERP process?
I don't think it's a foregone conclusion that it's sunk. I mean, I think that if prudence reviews, as we've discussed, is a assessment of what information was available at the time decisions were made. So if it could be determined that the company proceeded with a more expensive alternative when it knew a less expensive alternative was available, I think that would be an opportunity for a party to raise questions about prudence.
Is it fair to say that showing a specific investment is imprudent can be difficult and subject to appeal risks by a utility?
I think there's a high bar for that, certainly, yeah.
I think you've been at the PUC since late 2017. How many times have you seen the PUC successfully deem a utility investment imprudent, putting aside Storm Uri, which was unique?
I'm trying to think. I know there were cases where there were prudency determinations that were subsequently reversed on RRR or through district court. So
in fairly egregious circumstances, right?
So yeah, I wouldn't take the lack of determinations of imprudence necessarily as a conclusion that this process is ineffectual. I mean, one way to interpret that is that, especially when the commission is reviewing historical investments, that the possibility of a determination of imprudence leads to more responsible investments by the utilities.
I mean, maybe they can look at the same track record we're discussing.
Right, but what I'm suggesting is that you may have had more opportunities for determinations of imprudence had it not been the case that utilities knew that investments they made were subsequently subject to these reviews in a rate case.
All right. Let's turn to the DSP. I believe Mr. Herring testified that base rates would increase by at least 30% by 2029. And I think when he gets underneath it, maybe significantly higher. All right, well, let's phrase it this way. Mr. Harrington testified that capital spending was about $755 million off an Appendix A rate base of $880 million and off an actual rate base of $664 million. Is it fair to say that capital spending has the potential to significantly raise at least base rates?
Yes.
So given that distribution spending is almost as large, well, is a 30% part of total investment, but unlike generation has little or no offsetting cost savings or rate impact. Can you talk a little bit more about why we can't do in the for distribution what we do in the ERP? Why can't we set an expected capital expansion plan that can be adjusted over time through a notice and comment process, and in a way that balances rate impact concerns with reliability, given the potentially perverse utility financial incentives to grow rate base that we discussed. And you mentioned that, these are, less lumpy, less subject to a CPCN. But why can't we spend baseline capital spending that sets a presumption of prudence if it's at it, a presumption of imprudence if it's below it? We've already heard from Mr. Bacorny that he doesn't take into account rate impact or costs at all in his distribution planning process. So, why can't we do the same thing here?
I would say that, the first reaction I have to that is that the baseline that you're referring to would the basis for setting that baseline is a complicated matter that inherently relies on forecasts that are speculative and subject to change. I think
Unlike
that
generation.
Well, I don't, I'm less familiar with the ERP context, but I'm talking about rate making here. So a reason staff has preferred relying on investments already incurred and sort of reviewing actual costs and revenues and expenditures in a rate case is because we find that there's a much higher value of the information we get when we can look at receipts and we can look at projects that actually occurred and dollars that were spent, as opposed to forecasts, which the utility has a lot more control over a forecast that they present. It's much, I think in both the historical and a forecasted context, we're always dealing with an asymmetry of information about the utility's activities. And I think that asymmetry of information is more problematic in a context where rates could depend on a utility's forecasts, which are much harder to get into. The assumptions are much harder to question.
Do we do future test years or multi-year rate plans around ERPs? I'm not proposing a multi-year rate plan. I'm not proposing a future test year. I'm just saying, let's look at capital spending in the context of a rate impact model and try and set levels that balance rate impacts with reliability concerns, given potential perverse incentives to grow rate base and earnings. I don't understand. I'm struggling to see why we can't do that.
Well, I think that in practice, the capital level would likely or could potentially be interpreted by a utility as a blank check to spend up to that level.
Well,
and then if you imagine a scenario where sort of in the interim period over which, I don't know what period you envision that level to be set at, but if you imagine that a utility has reached that level and then they come to the commission and say, oh, by the way, here's a new reliability problem we have and we need to exceed the cap, I think it puts the commission in a very difficult position of saying, no, we're not going to allow you to exceed the cap to address a new reliability concern that has come up. So I think it presents opportunities for sort of gaming the system. I think I mentioned in my testimony that in practice, I think it would more likely to act as a floor than a ceiling.
Don't we deal with this all the time in the generation side? The world changes, they submit a request to change, and we either approve it or not.
Well, and my sense is that this is a source of frustration for the commission, right? That when something has been approved and then there's an additional resource adequacy constraint, that's problematic.
Did staff look at the potential long-term rate impact of the 80% increase in distribution capital spending? Do you have any idea what the rate increase associated with that is?
With the distribution specifically? I No, I have reviewed the both models Mr. Harrington attached to his testimony, but I don't know that number off the top of my head.
All right. If the utility had proposed to increase spending by a factor of 3 or 5, would you have taken a different position in this case, or would you have tried to dealt with that through after the fact prudency review?
I think it would depend a lot on the nature of the capital spending that they're proposing. What I see in this case is that the overwhelming, or I will say the majority of capital, the distribution capital they're proposing to invest in this DSP period is maintenance and reliability investments. I think you presented the question earlier to, I don't remember if it was Mr. Buckhorny or Mr. Ahrens, that you see this as potentially a trade-off between rates and reliability. The commission could give guidance to reduce reliability in the interest of lower rates. I think that would be, I don't think that staff would, make that recommendation, but
why not? Why not? I mean, on the generation side, we accept that whatever 1 in 10,000 days there's going to be an outage. I mean, there's clearly cost and reliability trade-offs everywhere. I just don't see how we're in any way looking at that here. It's just, yeah, reliability is great, so spend whatever you want. And then we're going to try and deal with it after the fact prudency in the context of a general rate case with 100 and 200 other issues once the investment's already sunk. Why not try and do that trade-off in this case?
I guess I would say from staff's perspective, we think of safety and reliability investments as as a different category from some others. I mean, it's sort of within the traditional paradigm of safe, reliable, and affordable service. I think the way we think of it is what is the most cost-effective way to ensure a safe and reliable system. It's unlike other types of investments where you want to subject it to a cost effectiveness test or something like that. I mean, if the commission is comfortable with the lower level of reliability, I suppose they can express that and allow utilities to adjust accordingly. But the way I've always thought of it is, what is the most cost effective way to ensure a safe and reliable system?
But at some point you got to put a limit. It's like on the gas side, Excel has doubled or tripled its safety and integrity investments because of that staff at it. It's because nobody looks at it for affordability lenses. So I'll just ask it this way. On page 10 of your answer to testimony, you state that staff shares the commission's interest in wanting to limit rate increases to customers. Given the limits of after the fact prudency review and the fact that you don't know the rate impact associated with the distribution investment in this case, what is your strategy for limiting rate increases, ensuring that rates remain affordable? I just don't see any balancing. It's the utility says you need it for reliability, and staff blesses it.
Well, I don't know that staff blesses it. I think staff reserves the opportunity to review the actual investments that the utility made when it comes into a rate case.
And again, you can't cite a single example where the commission successfully held.
Chair Blank, with all due respect, I would ask that it sounds like some of these questions are criticisms you have of staff regarding staff strategy and its litigation. To the extent that those questions involve questions about the Black Hills DSP proceeding, I think that that's appropriate. But this is really, I feel like there is a level of hostility being expressed towards my client that I just cannot sit here and abide anymore.
Fair enough. View it as frustration in this case. It has nothing to do with any other case. I'm confronted with a unanimous settlement agreement and a record that's very difficult to do anything about. And that's the source of my frustration. It's entirely in this case. And I'm just struggling with how we maintain affordability given the limitations of after the fact prudency review. So yeah, there's some frustrations here. Uh, so I don't know. That's my last question. Mr. Haglund, anything you want to say?
Nope, nothing further from me.
All right, Mr. Smith, you're welcome to redirect if you want to take a break. We can do it after lunch if you want to. I apologize for my frustration and tone.
Understood. I just have like a very couple of questions so I can finish them in a couple minutes tops.
Yeah. All right. Go ahead.
Thank you, Mr. Haglund. Understanding that you did not file answer or settlement testimony in this proceeding, would you generally say that settlements represent a compromise among the parties?
Yes.
Would you agree that settlements in general have several different benefits, including efficiency, reduction in litigation costs, et cetera?
Yes, I would agree.
And does staff generally take into consideration many of different factors when deciding whether to enter a settlement agreement with the utility or with any other party?
Yes.
And that includes the potential impacts on other cases?
Yes.
That includes rate impacts?
Yes.
But ultimately, is it not true that the base question that we're really is to be answered is whether an agreement is just and reasonable and in the public interest? Isn't that right?
Yes.
And generally, that's the question the commission is really tasked with answering when a settlement agreement is filed for approval. Is that not correct?
Yes, that's my understanding.
So based on this and based on what you heard, do you have any reason to change staff's position in support of this settlement as being just and reasonable in the public interest?
No, staff continues to support the settlement agreement.
Thank you. I have no further questions.
Thank you, Mr. Haglund. If my frustration got the better of me, I apologize. I appreciate the dialogue and hope going forward you'll at least take a look about how the generation approaches can be influence cases like this in terms of affordability. So if you're open to thinking about it, that'd be greatly appreciated.
Sure. Thank you, Chair.
Thank you. With that, let's go to lunch and come back, let's say at 12:45. Will that work for you, Mr. Sopkin? Is that
Yes,
through
sir.
your
Yes,
through
sir.
your fire alarm?
It hasn't started yet, so
All
hopefully.
right. All right, let's come back at 12:45 and see if we can finish up. Thanks all. Ms. Crampton, do we have Mr. Villarreal? Here you are. You hold up your right hand, sir. You swear to tell the truth, the whole truth, and nothing but the truth.
I do.
Put your hand down. Is anybody with you or communicating with you in any way?
No,
That changes. Will you let us know?
I will.
Back to you, Ms. Crampton.
Thank you. Good afternoon, Mr. Villarreal. How are you today?
I'm doing well. Thank you. Thank you.
And Mr. Villarreal, can you explain your involvement in this proceeding on behalf of the utility consumer advocate?
Yes, I am the consultant hired by UCA to review and provide testimony on this filing.
And in this proceeding, did you provide what's been marked as hearing exhibit 300, which is answer testimony of Chris Villarreal, as well as hearing exhibit 301, settlement testimony of Chris Villarreal?
Yes,
And if I were to ask you the questions that are contained in those two pieces of testimony again today, would your answers be the same?
they would.
Thank you. Mr. Villarreal is available for cross-examination.
Mr. Sopkin, I got an hour and it's 12:47.
It's going to be a lot less than an hour, Your Honor. Mr. Villarreal, I believe we met about a year ago in California at NARUC, so it's good to see you again.
It's good to see you too.
Just have a few questions for you. You are UCA's only witness in this case, so you are essentially representing UCA's interests in this case.
I am their only witness, correct?
Okay. So I want to, well, first, would you agree that the parties to this case, UCA, Black Hills, and staff, have settled every issue in this case except for one, which is whether a waiver should be granted under Rule 35, 31, A2, A through F regarding hosting capacity analysis and mapping?
I agree that a settlement has been reached. I believe reflects the characterization you just provided.
Okay. So with regard to that one issue, and I could refer to your testimony if you like, but is it your memory that you stated in your testimony that Black Hills apparently only looked at the costs of the project without looking at the associated benefits such information would provide itself and to its customers? Do you recall that?
That sounds about right.
And so would you agree that the commission should be looking at this as sort of a cost benefit analysis?
I think that the information provided by Black Hills provided by Black Hills in this proceeding should explain the rationale for why it did or did not choose to meet the requirements of the rule, and that would include things like if that would include things like costs as well as potential benefits to its customers of doing something.
Okay, fair enough. Looking at the cost side, would you agree that Black Hills has identified two cost components? On the one side, there's the hosting capacity analysis and map. And then in addition to that, there's a cost associated with a web portal. Yeah, I'll stop it there. With a web portal.
Yeah, I believe that's accurate. That there's the cost to generate the host capacity analysis and the map, and then there's the presentment of the map.
Right. And so what I'd like to clarify, and let's refer to your testimony, hearing exhibit 300 at page 23. if we go down to line 18, lines 18 to 21, similar to my comments on hosting capacity analysis and maps, Black Hills needs to provide information about the distribution system via an online portal. And this is vital to the development of DER across Colorado and for Black Hills customers. I paraphrase that a little bit, but is that correct?
That is correct.
Okay. And what I'm trying to get a sense of from you is what you would like to see in the online portal. Because you recall that Mr. Harrington has filed testimony indicating that the ICF estimate for providing sort of I'll call it a full-scale online portal is somewhere between, I think it's $500,000 and $800,000.
I remember his statement.
So what I'm trying to get, and so what I'm trying to do is get a sense of what you believe needs to be in that online portal.
Sure. So my recollection of Rule 3541 covers a lot of other information that the rule has suggested be made available. And so as it applies to the discussion here in this testimony, as it applies to Rule 3541, it is more reflective of all the things reflected in 3541 that the Commission has suggested be made available. So that would include things like an online portal to show all the list of investments that Black Hills intends to make. So that is in essence what this section of the testimony is talking about. As it applies more specifically to the availability of a hosting capacity map, what I would anticipate being provided is a web-based version of a Google map or an ArcGIS map that provides an outline of Black Hills' distribution system. Again, that's part of, I believe, the overall guidance in Rule 3541 is to do such a map, but that is what I would envision for the hosting capacity mapping component of this is some map like that.
Okay, and would you agree that you did point to a couple of map exemplars in your testimony? And I believe actually you provided the maps in your 2023 testimony, but not your 2025 DSP testimony. Is that correct?
Yeah, I did not provide any examples in the 2025 testimony. It may be correct to say that I did so in the 2023 testimony.
Okay, and so if you don't mind, if we could take a look at your 2023 testimony, which get that. It's hearing exhibit 108, which we put in box. All right, and I will represent, we just excerpted four pages from your testimony because this is just for the purpose of showing these maps that you pointed to. Okay, so first let's go to page 4. On the bottom of page 4, there you indicate lines 7 through 9 that the Commission's Rule 3531, A2, A through F, requires Black Hills to prepare a hosting capacity analysis and make such information public via a hosting capacity map, similar to examples as shown above. You see that?
I see that section, yes.
Okay, and so if we scroll up to the second page of this document, so on page 27 of 40 of the testimony you filed back in 2023, you listed a map from Pepco, which serves Washington, D.C., correct?
Correct.
And there you say lines 3 through 5. If you in the image, you can see the locations of the underground network distribution feeders across most of Washington, D.C., correct?
Correct.
All right, and then scrolling down a little bit here, you said another example, this is line 6, is a heat map provided by Southern California Edison Company. This is a picture of SCE's heat map for the city of Anaheim, California. John Wayne Orange County Airport is in the middle of this image. You see that?
I see the words.
Yeah. And so if we scroll down to the next page, and this is the SCE map you're referring to, right?
Correct.
And as you say, lines 1 to 2, the blue dots represent the location of substations within the area of the picture, correct?
Correct.
All right, and you're familiar, well, let me start with this. Would you agree that that Pepco and SCE are much larger utilities in terms of number of customers than Black Hills Colorado Electric?
I would, yeah, I would agree that they are larger in number of customers.
Yeah,
To the best of my
and
knowledge, yes.
Google tells me Southern California Edison 5 million electric customers, Pepco 900,000 electric customers.
Mhm.
Any reason to disagree with that?
Nope.
Okay. So are you familiar in this case that the company has made a map available to developers who sign a non-disclosure agreement that is a KMZ type file accessible through Google Earth?
I am aware that Black Hills has stated that in their documents in this proceeding. Yes.
And Black Hills made that available to parties to the 2023 case through its filing of its July 1, 2024 report. Do you recall that?
I was not part of that effort. So to the extent you say that you did it, I will accept that you say you did it.
Okay, so that was my next question. Have you had an opportunity to actually look at the map via Google Earth?
I have not looked at that map.
Okay. And if I tell you that the map shows the company's distribution and feeders as well as its substations across its service territory, would you have any reason to disagree with that?
That is what has been represented by the company. I've not looked at the map, so I guess I'll take your word for it. But I have not looked at the map, so I'll just trust you in that, I guess.
Okay, and looking, if we can go back, we can take this down. If we could go to hearing exhibit 300 in this proceeding, looking at page 20. Thank you. Lines 7 to 12. You indicate, I'm not suggesting that Black Hills needs to invest in a highly detailed map, heat map, or outfit its distribution system with real-time telemetry to conduct a daily hosting capacity analysis. Rather, any information about a system hosting capacity can be useful as long as the information is accurate it is well understood that a hosting capacity analysis only reflects a moment in time. You see that?
Yes, I see that.
Okay, so you're accepting my representation that the company does offer a map showing, you know, the distribution and substation facilities, and you presented a couple maps in 2023 showing those things as well. Is the main difference that the ones you're showing are what they call a heat map?
So yeah, so the main difference between whatever it is that Black Hills has provided to whoever has asked for it and what has been asked for by, or what has been provided in other utilities, is that those utilities have clearly a whole lot more information about their distribution system. And so to the extent that the recommendation is for Black Hills to do a hosting capacity analysis and the associated mapping, it's really to leverage the available information that Black Hills has and put that into a more publicly accessible and standardized form for utilization by consumers, developers, local governments, and whomever is interested in better understanding the distribution system to take more control over what it is they want to do.
Okay, but you're recognizing that in the case of Black Hills, at least at this moment in time, you're not suggesting that we need to invest in a highly detailed heat map, as you put it.
I'm suggesting that Black Hills has a lot of information about its distribution system, and that information can be translated into a more standardized, publicly accessible hosting capacity map, leveraging whatever available data it currently has.
Okay, and Black Hills has presented its estimate of costs for doing so, and would you agree that that you have not looked at the cost side of the equation?
I've read the ICF report.
Okay.
And I guess what I'd say about the ICF report is it's unclear to me what the costs actually are recovering.
I didn't ask you questions about that report at this point. Right now, I'm just trying to establish what you looked at on the cost side of the equation, and if we could pull up your discovery response on this issue, it should be hearing exhibit 105, attachment DSA-1. And turning to the second page of this document, Black Hills asks the question, please provide UCA's estimate of the costs associated with the implementation of Mr. Villarreal's recommendations that BHCOE, and it goes on, there's several subparts to that. But before we get to the subpart, the last sentence before this subsection A, it says, UCA is not required to provide cost estimates or cost benefit analysis of programs required for utilities under these rules. Moreover, Mr. Villarreal does not have access to cost information and provided no testimony addressing any potential cost issues. Is that what that says?
I'm going to just interject, I guess, and object. I think what Mr. Sopkin is reading is an objection. So that would be language sponsored by counsel, not by Mr. Villarreal. And UCA continues to assert its objections.
Mr.
Well, first of
Sopkin.
all, this is already in evidence. This is part of Mr. Aaron's testimony. It was introduced into evidence, so I'm not sure what the objection is, but it's certainly a statement from UCA, whether it's its counsel or not, asserting that Mr. Villarreal himself does not have access to cost information and provided no testimony. I think it's entirely relevant and it's already in evidence.
Overruled.
Okay, if we could scroll down to the next page under subsection B, This is costs related to developing a hosting capacity analysis and make available a map showing the results of its capacity analysis. And under the response part, the first sentence is UCA has not independently developed a hosting capacity analysis, does not have an estimated cost for any such analysis. Is that what that says?
Those are the words on the paper and on the screen.
Okay. Thank you. We could take this down. Okay. So again, getting back to this idea of how much Black Hills should be required to do at this stage with regard to its hosting capacity analysis and map progression, if you will. You've heard you were here for Mr. Aaron's testimony and Mr. Harrington's testimony. Is that correct?
Yes.
So you heard their testimony. And as I recall, that testimony included a statement that developers can come to the company and seek information regarding hosting capacity opportunities, and on an ad hoc basis, the company can work with those developers. Is that something that you believe would provide useful information to developers?
I do not believe that that would provide useful information to developers. I think the developers are looking for opportunities to locate stuff. Consumers are looking for opportunities to invest in DER of whatever variety of DER we want to talk about, whether it's solar plus storage, electric vehicle charging infrastructure, what have you. The ability to access such information provides a cost savings to the consumer and to the developer that they would otherwise have to bear if they had to wind through utilities web pages, track down a contact information, deal with a confidential and proprietary data source, and then sign an NDA, which then requires review by their legal team to determine whether or not they're even allowed to sign the NDA. Those are all barriers and increased costs to the consumer and to the developers. And so the fact that there are some developers that are happy to do that just means that there are some number of developers that are not happy to do that. And so that means those consumers have lost that opportunity to work with potential developers or to take solutions in their own hands and decide they want to invest in something because they are not easily able to access that information.
Okay, and if it turns out, as a hypothetical, that the cost of that plug-and-play system you're talking about is somewhere between $300,000 and $800,000, your testimony is still that that should happen. The company should go ahead and make that expenditure before its next DSP file.
Well, remember, the benefits don't only accrue to consumers seeking to invest in DER and to DER developers. Benefits of doing the analysis also accrue to the utility because now they have better information about their system.
Sir. Can you answer my question?
Can you please rephrase it or repeat it?
If the cost turns out to be between $300,000 and $800,000 for the company to develop that plug-and-play system that you just described, you believe that the company should go ahead and make that expenditure before the next DSP file?
Jack, this was asked and answered.
No, it wasn't.
I overruled.
The ICF report provides varieties of investment opportunities for the utility to meet the requirements of the commission rules. One option is certainly the
Sir, would you
up to
answer my question,
$300,000. There's another option. I apologize, Mr. Stockman, I interrupted you.
Is your answer yes to that question?
My answer is there are costs that would need to be recovered to do it, and there are a variety of ways to do it.
Okay, thank you. Would you agree, or have you looked at, and I don't want to go into confidential sessions, so I'll just ask this question, that the company has provided confidential appendices I and J to its DSP report. So that's hearing exhibit 103, attachment tab 1, that shows the peak loadings and capacity margin of each substation transformer and feeder on its system?
I'm
Or have you
aware,
looked at it?
sorry, I'm aware that in the DSP, there is a number, there are at least two confidential tabs that provide information about the distribution system.
Okay, thank you.
And that is one information. And then there's daytime minimum load, which is also part of the DSP.
Okay, thank you. And then in your settlement testimony, which is hearing exhibit 301, you pointed to certain materials issued by the Department of Energy, the Interstate Renewable Energy Council, or IREC, and by the Michigan Public Service Commission. Is that correct?
Correct.
All right. And I just want to look at a couple items there. Hearing exhibit 301, attachment CV-2. Page 28. If you could scroll down to the bottom of this page. Okay, so right now we're dealing with a page number issue. This says page 26 at the bottom. Can you go to where it says page 28 at the bottom? Thank you. That's good. Would you agree that this report from DOE states, and I'm looking at, well, let's scroll up to the top. So there's a chart here that says California DRP Working Group potential DER value. See that?
Yes.
And there's in the left margin, it lists value components. You see that?
Yes.
Scrolling down from there, the document states, in practice, these concepts are usually considered together. That is, in most instances, pursuing market animation without some level of DER adoption is unlikely to succeed, given that distribution market opportunities for non-wire alternates are relatively modest in comparison to those potentially present in wholesale markets where available and needed. Do you see that?
I see those words, yes.
Okay. And then turning to page 35 of this document where it says page 35 at the bottom. It's probably page 37 is my guess. If you can scroll to the bottom. Okay. Under utility capital investment heading 3.3.1, the last sentence there states the capital investment may also make the most sense for long-lived assets due to their long depreciation periods and lower potential rate impacts when compared with short-lived assets, such as software or the operational expenses under an outsourced services arrangement. Do you see that?
I see those words, yes.
Okay, that's all I have for you on this document. Turning to hearing exhibit 301, attachment CV3. Going to page 6, again, it's gonna be where it says page 6 at the bottom. Or at the top. Okay, that works. Scrolling up a little bit. All right, under the heading of costs, 1.3 costs, you'd agree the document states utilities will incur a variety of costs to implement HCAs. Performing an HCA involves validating the data used as inputs, preparing the feeder models used in the power flow simulations, running the power flow simulation, and providing the results to stakeholders. Each of these steps involves certain software, hardware, and human resources. You agree that's what the document states, right?
That is what the document states.
Okay, then turning to page 7 of this document, one page down. And here the document describes a stakeholder engagement process that should occur as part of the HCA adoption. Would you agree with that?
Yes, this section provides suggestions for regulators to develop a stakeholder process regarding what the goals of a hosting capacity should be.
Okay, and scrolling down a little bit. Okay, this is the second paragraph. In a stakeholder engagement process, stakeholders and regulators openly discuss the key decisions identified in this paper. These processes can be in advance of regulators directing or guiding the design of the HCA, as a middle step after regulators have already determined to proceed with an HCA, or both, right?
That's what the words say.
Okay, so here's the question where I'm leading to. You'd agree that Black Hills is not requesting a permanent waiver of Rule 3531. This is just for this proceeding. Do you agree with that?
I agree that what's been requested is a waiver for this distribution plan to not do a hosting capacity analysis and associated mapping.
Okay, and but the company is seeking the ability to request a waiver in its next DSP filing based on the most current information available as to costs and benefits of HCA analysis and mapping.
I would agree to the cost side. Again, I do not believe that benefits have been appropriately accounted for.
Okay. So you'd agree in this proceeding, no developers sought intervention. There are no other developers in this case, right?
Correct. No, it's just staff, UCA, and Black Hills.
And in the last DSP proceeding, only one developer intervened, Pivot Energy, and what they really wanted was a map, and the company actually provided that map.
I'm
Is that
going to
correct?
object. I'm going to move to strike that question. I think it's counsel testifying. I don't think it's relevant who intervened in the last proceeding or what their positions were. And we certainly don't have any evidence of that prior proceeding and who the interveners were and what their positions were. It also asked Mr. Vreel to draw a legal conclusion. There could have been people that petitioned to intervene and that intervention wasn't accepted. And I don't think this witness is suited to answer those questions.
That's sustained, Mr. Sopkin. If you could just reword the question.
Yeah, and actually, I'll move on from there. The question I'm leading to is, instead of the commission ordering the development of HCA and mapping now in this case, would UCA be amenable to requiring a stakeholder process with developers in the interim before this case and the next case to discuss with developers, local developers, in our service territory, what they would like, what they would need, what they think would be beneficial in order to determine a reasonable solution and a reasonable cost.
I believe that that is probably something that Black Hills should have been doing all along. I believe that was certainly the spirit of the original rule. That was certainly the spirit of what we're of. I believe that that is part of something that's already been required, in my opinion, by the commission rule for Black Hills to do, is to do
Well,
stakeholder meetings.
you've again, you said you heard the testimony in this case, and I'm sure you've read Black Hills testimonies. Black Hills has indicated they have talked with developers, haven't they? And the developers indicated that they were happy with the map information provided.
I think the difference here is that the ad hoc manner in which the outreach is occurring is not very sustainable, and it's subject to cherry picking of who is going to be asked what in what type of stakeholder meetings that you want to have on a one-on-one basis. In other words, a more robust stakeholder meeting would happen in a more public and open and noticed setting rather than on an ad hoc one-on-one basis.
Okay, and what I'm suggesting right now is instead of requiring Black Hills to incur this expense for HCA and mapping and some sort of public-facing web portal, how about the commission ordering that we engage in a stakeholder process that is noticed, in which UCA is invited and staff is invited, and we can discuss what is the best solution, and the company can present a report prior to, or the company can present a report in the next DSP filing. Is UCA opposed to that?
My position would be that you're already required to do that.
We're already required to present a report.
No, you're already required to conduct outreach and stakeholder meetings to discuss the components of your distribution system plan.
Okay, but the idea here, again, not to be cute, is instead of incurring the expense now, finding out from developers what they really want, which could cost a lot less than your plug and play solution.
So I don't view it as an either or, respectfully. I think, again, doing those meetings is something that the utility should have already been doing. The commission's rules already require you to provide either a distribution system plan, or to do a distribution, to do a host capacity analysis and associated mapping. And I believe, the utility is free to continue to do stakeholder meetings going forward. But I don't think that's a substitute for the request that we are seeking here, which is to have a host capacity analysis and mapping be completed.
Well, you'd agree that neither UCA nor you have ever surveyed or asked any developers active in the Black Hills service territory as to their desire to have web portal access for distribution system capacity?
I'm going to object on relevance and burden shifting.
Overruled.
Could you repeat the question, please?
You'd agree that neither you nor UCA have surveyed or asked any developers active in the Black Hills service territory as to their desire to have web portal access for distribution system capacity?
I have not done such a review. I cannot speak for what has occurred in other proceedings in which I am not working for UCA.
Okay, so you're not familiar with UCA having done that?
I'm not aware of it, but that does not mean it hasn't been done. I'm just not aware of it.
Okay, moving on to moving on to the last set of materials you presented. This is hearing exhibit 301, attachment CV4. All right, and this is a Michigan Public Service Commission order that you attached to your settlement testimony, case number U-20147, correct?
Correct.
And this is an order addressing a staff report regarding distribution, investment, and maintenance plans applicable to 3 utilities: DTE Electric Company, Consumers Energy Company, and Indiana Michigan Power Company. Is that correct?
Correct.
And again, I Googled it. Do you have any reason to disagree that DTE has 2.3 million electric customers in Michigan? Consumers Energy has 1.8 million electric customers, and Indiana Michigan Power Company has 600,000 electric customers.
I have no reason to disagree with those numbers.
Okay, and so the examples that you pointed out here involve utilities that are anywhere from 6 to 23 times the size of Black Hills Colorado Electric. Is that about accurate?
As it applies to the size, correct. Sorry, let me say that. Let me say it a different way. I'll trust your math on that. I think as it applies to the docket that the Michigan Commission was trying to deal with here, the utilities are not in a dissimilar situation regarding cost concerns.
You'd agree that it's easier to spread out costs with a higher denominator, i.e. number of customers, than if you have a lower denominator?
That would depend on the economic makeup of the customer base.
Okay. You're familiar with the economics of the customer base for Black Hills Colorado Electric, correct?
I am familiar with the economic makeup of the customer base, correct.
Thank you. And then this will be the last question. Turning to page 6. Scrolling down. All right, hold on. If you can scroll up a little bit. Can I ask you to do a search of the word primary objectives? All right, so what I meant is page 9. So you'd agree this order states that the commission established 4 primary objectives for the distribution planning effort. Number 1, safety; 2, reliability and resiliency; 3, cost effectiveness and affordability; and 4, accessibility. You see that?
Yes, I agree that the Michigan Commission identified those as 4 primary objectives.
And then turning to page 37 of this document. And this page 37 talks about the 3rd primary objective, cost effectiveness and affordability. And second sentence, the commission expects upfront analyses to ensure investment strategies are reasonable and prudent, alternatives are thoroughly considered, and longer-term operational savings from new investments can flow through to customers, thereby keeping rates affordable. That's what it says, right?
That is what it says.
Okay, I have no further questions. Thank you, sir.
Thank you, Mr. Supkin. Staff counsel, Ms. Chong.
Thank you, Chair Blank. Staff waives its cross of Mr. Villarreal.
Thank you. I just have two questions for you, Mr. Villarreal. Is UCA concerned about the rate impacts of increasing annual average distribution capital spending by roughly 80% over the coming years?
Um, I don't know exactly the answer to that question, Mr. Chairman. I would say generally that increased costs overall would be a concern. And the point of doing a distribution system plan like this is to get your arms around what those costs are, and are there ways to manage and mitigate those by looking at alternatives or other ways to get more juice out of the squeeze, so to speak, from the existing system. And so um, I think that's one of the things that the purpose of one of the purposes of this proceeding is to figure out, is this being planned effectively? Is the distribution system plan being planned effectively and efficiently? And the purpose of your rules, amongst many of the purposes of the rules that adopted by the commission, is to have more information about the system be made available, be more transparent, so that the commission and appropriate interveners can look at those investments and figure out, are these investments aligned with the plan? And is the plan a reasonable plan?
All right, given the small size of the utility and the fact that you didn't talk to the developers, shouldn't we talk to the developers before, through some process, whether it's the stakeholder one that Mr. Sopkin suggested before we order this expense?
Well, remember, the developers are not the only ones that will benefit from doing a hosting capacity analysis overall, right? Um, One of the things that I'm aware of in other state proceedings through my conversations is that utility GIS systems are often inaccurate. And if you're going to host capacity analysis, you're relying on accurate information to support it. And so going out and talking to a developer, you'll get one perspective of what the developer wants, but then we're not accounting for the overall benefits to the distribution system planning effort itself. And so if something like the GIS is inaccurate, then that impacts the ability of the utility itself to effectively manage and operate its system. Um, Developer perspectives are of course important, but so are the consumer perspectives. And so is the utilization of information that is supposed to be collected through the tech, through what the utility has today, and leveraging the host capacity analysis to help inform those investments.
That's all I have, Ms. Crampton, redirect.
Thank you. If I could have just a moment.
Mr. Chair, I believe I did not move the admission of hearing exhibit 108. If I could move for that admission.
Any objection?
Sorry, I didn't hear you, Mr. Sopkin. I think you said 108, and was that the 4-page?
Yes,
Okay, no objection.
So moved.
thank you.
Mr. Villarreal, just pick up where you left off with the chairman. You indicated that you view hosting capacity analysis as a way to get arms around the company's distribution system and distribution costs. Is that right?
Correct.
And is that one of the benefits, when you stated in your testimony, Mr. Sopkin had asked you about this, that the company had failed to consider the benefits in its cases, is that one of the benefits that you meant?
Yeah. To generate a distribution system plan, one of the foundational components of that is information. And a hosting capacity analysis generates information about the system. And that information then is supposed to inform the investments that the utility wants to make in its distribution system plan and then through its rate case. And so the information is generated through hosting capacity analysis is supposed to help a utility better plan and be more efficient in its operations to identify locations that need to be addressed, locations that may not need to be addressed. And it has an overall internal benefit just to the operations and planning of the system overall.
And is there a difference that you see between a hosting capacity analysis plan that makes this information accessible, as valued as a principle by Michigan PUC, makes it accessible versus an ad hoc information provided only to developers who've signed a non-disclosure agreement? What's the difference between those two types of systems?
Sure. So when you have a hosting capacity analysis that is based on a standardized process and standards itself, then you have opportunities for consumers and developers to know what it's going to look like, what the process that was used is going to result in. It also then provides benefits to the commission and to any other stakeholders to know that this was followed in a standardized manner. So the importance of standards is, of course, to standardize things. And when we have things that are done on a non-standardized basis, then that risks increased costs to developers, to consumers, and perhaps even to the utility itself as they rely upon proprietary manners in which information is generated and then developed. So having a standardized process and the standardized process to access it and made it available provides overall benefits to the provision of that information in that map.
And you talked about what you think the spirit of the rule 3531 is that rule reflective of a standardized process for utilities in Colorado, as you understand it?
I certainly agree that the commission was looking for consistency across a utility planning process. They were certainly looking for consistency in the information that's provided, and they're looking for consistency in the results of those requirements in that section of the rule. And so when you have a non-standardized product coming out of a standardized process, that just makes things less efficient and more costly for everyone, frankly.
Do you recall Mr. Sopkin had showed you, these were quotes from two of the attachments that you provided to your settlement testimony that had a discussion of long-term capital investments versus short-term capital investments. Do you recall that question?
Yes.
And then kind of a second question about short-term investments related to hosting capacity analysis development. Do you recall that second passage?
Yes.
Do you think there's a relationship between a short-term investment like development of hosting capacity analysis and a company's long-term capital investments?
Yes, and certainly in the purpose of that DA report is to make those alignments more apparent to regulators, utilities, and other stakeholders. When you're looking at a distribution system plan, and as reflected in the commission rules, you have a starting point of today that's supposed to look out into the future. And you have your information available today. You have the best information available today that's informing what you're going to do over time, or it's supposed to inform your planning process over time. And so investments that are made today are supposed to be in alignment with the goals and objectives, in this case, of the commission and the state. And those investments are supposed to then allow for greater growth and meeting the goals and objectives identified by the commission and the state. So yes, there's a relationship between what goes on today and what can be enabled over time.
And Mr. Sopkin had asked you some questions about whether UCA looked at the costs of the hosting capacity analysis and cited to a discovery response. But I think in the course of that back and forth, you had tried to explain that you've reviewed the ICF report and the costs contained in there. Is that correct?
Yes.
And is it your understanding that Black Hills already possesses some of the information that would go into a completed or developed hosting capacity analysis?
Yes. So based on the filings, the information provided in the DSP and the information as discussed earlier today, it sounds to me that Black Hills has a good starting point of information already and already available to help generate a hosting capacity analysis and have information that is available and can be made available through a mapping function um, for developers, consumers, and for utilization of their distribution system planning effort.
Okay, and if Black Hills in fact has that information or some of that information already, could that impact the cost associated with sort of completing the development of the hosting capacity analysis?
I believe so. The basic premise here is that the starting point is what you have, and so they have a good starting point, and that's supposed to be done better over time. And having a starting point, Black Hills seems to have a good amount of information to start with.
And having good information to start with, is that something that could result in perhaps something other than the $290,000 option that Black Hills has cited in their testimony?
Yes. The availability of information starting today, or what is currently available to Black Hills today, certainly in my mind means that data collection cost for doing something with their available data is already something they do. And so if it's something they already do and is already available in their normal course of business, then translating that into a mapping function and to a more broader HCA means we're just taking the data and making sure that it fits into a standardized process to then grow over time to start, making sure that the process is started using available data, and over time, that information, and as Black Hills invests in more things in their system, to the extent approved by the commission, then we have a process that's started, and the data can then be more effectively and efficiently put into the standard process.
Thank you, Mr. Villarreal. I have no further questions.
Thank you. You may be excused, Mr. Villarreal. Thank you. I guess, Mr. Sopkin, do you know how long it might take for Mr. Harrington to prepare that exhibit, like a week or two, or any guidance?
Yeah, I do know Mr. Harrington is heading to Nehru next week. We're thinking we might be able to do it in a week. Kind of depends on how much time he has available, but certainly no more than 2 weeks.
All right, let's make a statement of positions. Do maybe Ms. Rosati, do you have a recommendation? Maybe 4 weeks from now? Like say August 21st, something like that.
I think that the current procedural schedule includes that SOPs would be due August 22nd.
Oh, all right. So we don't have
But
to change anything. And if we need to
Um,
adjust, we can.
but I think you know, Miss McLaughlin raised whether there would be an opportunity for other parties to respond to what Black Hills would be filing. So if the other parties would like an opportunity to respond, I would suggest pushing back the SOP deadline further.
All right, you want to say August 29th? And we'll adjust once the exhibit's filed if we need to. So Ms. McLaughlin, did you have something else you wanted to add?
I think for the most part that works for us, but I do want to flag that August 29th is in the middle of the PSCO DSP hearing, which I know I am counsel on, and I believe Ms. Crampton might be as well. So that might impact some of our ability to get an SOP finalized by August 29th. And from staff's perspective, we support the settlement, but with this new additional information, we're just hoping to have sufficient time to review it because it has been out of the normal process of being able to have eyes on it.
Understood. Understood. Well, we'll do the best we can. Well, geez, I guess nobody wants to file early. Would you prefer, Ms. McLaughlin, August 22nd? It's a 2-week hearing.
I suppose we could keep it at the 29th, and we will do our best to accommodate everything.
All right. Mr. Sopkin, Mrs. Crampton, anything else before we adjourn for the day?
Nothing from Black Hills. Thank you.
Ms. Crampton?
No, thank you.
Thanks to all. With that, we're adjourned. We won't quite close the evidentiary record yet, and we'll take it from there. Thanks all.